magistrates, customary court presidents, officers of the Ministry of Justice, members of justice sector institutions, distinguished members of the inner and outer bar, distinguished learned colleagues, gentlemen of the press, ladies and gentlemen, it is a profound honor. It is a profound honor to contribute to the intellectual work of the Nigerian Bar Association Benin branch at the 2026 Annual Law Week. I commend the chairman, the executive committee, and the Law Week committee for the insight reflected in the theme, Reforming Today, Securing Tomorrow. This theme is not merely decorative, it is an urgent call to the legal profession to examine whether our institutions, our methods, professional habits, and ethical safeguards are strong enough for the realities now before us. The keynote address delivered at the opening ceremony on the positioning for effective justice delivery and democratic stability in Nigeria gives this session its larger constitutional context. If justice delivery is to be repositioned, if democratic stability is to be protected, and if tomorrow is to be secured, the legal profession must confront one of the most disruptive forces of the present age, and that is artificial intelligence. There was a time that AI was a very distant concept, a very distant technology, but not anymore, not anymore, not anymore. But the time that it was an experiment reserved for engineers, those at Microsoft, IBM, but now it's part of the daily vocabulary of business, of education, of medicine, of finance, of governance, and increasingly of the legal profession. It has entered the legal profession through research tools, document review platforms, drafting assistance, contract analysis systems, case management software, transcription tools, legal chatbots, and intelligent workspaces. It has also entered through less obvious laws like, for example, fabricated evidence, deepfakes, algorithmic bias, unverified summaries and professional reliance. We also have fake citations. The question is not whether AI is useful. The question is whether the legal profession can build the discipline, ethics, verification culture, and institutional safeguards necessary to use it without damaging justice. This paper proceeds from a central proposition that AI will not replace the conscience of the lawyer or the wisdom of the judge, but lawyers, judges, and justice institutions that understand responsible AI will lead the future of justice. The future will not be won by those who fear AI, nor by those who worship it. It will be led by those who can govern it, verify it, humanize it, and align it with justice. Artificial intelligence as a new frontier in justice delivery. Nigeria's justice system is under substantial pressure. Courts carry heavy dockets, while lawyers spend long hours searching through authorities, drafting processes and reviewing documents. Magistrates and customary court presidents deal daily with high-volume human disputes. Judges manage lengthy meeting addresses, voluminous processes, and records that often demand significant time before the real issues can be identified. Government legal departments face adversary, prosecution, contract, policy, and law reform bodies. Citizens, especially the poor and vulnerable, often experience justice as slow, costly, or inaccessible. Artificial intelligence matters because it speaks directly to these pressures. If properly used, AI can support legal research, organize facts, assist with preliminary drafting, identify missing information, summarize documents, prepare timelines, compare positions, generate checklists, track tasks, support court administration, and expand access to basic legal information. It can help the young lawyer begin from structure rather than from confusion. It can help the senior lawyer supervise systems rather than merely chase drafts. It can assist the judge in finding the needle in the haystack, provided that it never becomes the hand that writes justice. Yet, AI also matters because its misuse can undermine the same justice system it promotes to strengthen. Fake authorities may mislead courts, confidential client information may be exposed, deepfakes may corrupt evidence, biased algorithms may affect liberty, bail, sentencing, or administrative decisions. Untrained users may present machine-generated work as legal analysis, lawyers may become intellectually lazy, students may lose discipline, and courts may be influenced by summaries that are incomplete or subtly inaccurate. Accordingly, AI must be understood not as a toy, not as a mere productivity shortcut, and not as a replacement for the legal skill. It must be understood as a justice sector development, requiring ethics, regulation, institutional policy, data governance, and professional responsibility. So I'll be talking about the conceptual clarification of some terms that we may be familiar with or may have not come in contact with yet. What is artificial intelligence, LLMs, and AI in legal practice? Artificial intelligence simply refers to computer systems that are designed to perform tasks that ordinarily would require human intelligence. These tasks include understanding language, recognizing patterns, analyzing information, classifying materials, generating text, summarizing documents, making predictions, and assisting decision-making. In simple terms, AI simply enables machines to process information and produces outputs that appear intelligent. The meaning of large language models. They are commonly referred to as LLMs. LLMs are systems that are trained on very great human-like nature output or language. We have come in contact with LLMs. Some of them include ChatGPT, some of them include DeepSeek, some of them include Gemini. These are tools that can be gotten from the Play Store, or if you are using an iPhone or iOS from the store too. Microsoft Copilot and Perplexity. These are examples of general robots that have been given the name AI judges. But actually, responsible use of AI does not mean that AI is now a judge. It does not mean surrendering professional judgment. It means using intelligent systems to assist legal work while preserving confidentiality, verification, competence, ethics, and accountability. In this sense, AI is best understood as an assistant, not an authority, a support system and not a substitute. It is best understood as a tool and not a conscience. Applications of AI in legal practice and justice administration. The use of AI in the legal industry is no longer speculative. Around the world, AI is already being used to perform or assist with tasks that are central to legal work. In legal research, AI-powered platforms can search through large databases of judgments, statutes, regulations, and academic materials far more quickly than manual methods. It is also used in document review and automation. In commercial transactions, we use AI in the areas of due diligence and contract review. AI systems can extract losses, identify inconsistencies, do e-discovery, and flag unusual provisions and highlight risk. In litigation, AI can assist in reviewing emails, draft records, databases, scanned documents, electronic correspondence, and large volumes of digital material. This is particularly important in complex commercial disputes. So, let me just explain what I've been saying since. I've been opportunity to create some AI tools for lawyers and for people in other professions. And I can tell you that what would have taken the lawyer, for example, hours to do with the help of AI, you can actually do those legal research in less than 30 minutes and come out with what, sorry to say, an experienced lawyer of over 20 years at the bar would have done or struggled to do. When it comes to litigation support, the responsible use of AI has to do with how we communicate with AI, even when it comes to contract analysis. There are things that we have been doing wrongly, and I'm talking about them going forward. Most directly. In such courts, AI must reduce delay without reducing humanity. For High Court judges, AI may support file management, written address summaries, issue extraction, chronology building, and research support. For appellate courts, AI may assist in mapping grounds of appeal to issues, organizing records, comparing briefs, and locating authorities. Yet, judicial reasoning must remain principled, independent, and accountable. AI may assist the judge to find the link in the haystack, but it must never become the hand that writes justice. For the Ministry of Justice and the Judicial Service Commission, AI is an institutional governance issue. It affects law reform, legal opinions, prosecution management, public sector advisory work, digital evidence policy, judicial training, court administration, procurement, data governance, and public trust. Practical demonstrations of AI. If we must know how to use AI, we must also understand that there are ways AI should be communicated with. Because of time, I will not be able to give us details on how to communicate with AI, but I will just skim through it. The first practical point is what I coined as scope. We have scope, we have verify, and we have lawyer. The scope method simply means the following. It means situation, character, objective, parameter, and expected output. Yes. So as a lawyer, most of the time people have been able to teach how to communicate with AI. The first thing they do is they just type and compute AI is just a normal chatbot. Hello ChatGPT, help me draft this, help me write this, help me draft a demand letter and all that. But there are ways to communicate with AI. Let me give an example. Under the scope, let's say we want to talk about a lawyer handling tenancy dispute. We may instruct AI in this manner. We may say a client has come for situation. You must tell AI the situation. You must explain the character. AI has used the shape of whatever you put it in. To the medical doctor, it is a medical assistant. To the banker or to the accountant, it's an assistant depending on their profession. So as a lawyer, you must always make AI understand that it's acting in the character of a legal assistant or a legal or a professional, maybe you cannot say judge, but that's very sensitive, but you can say a senior lawyer or even a well-renowned professor or doctor of law, and it will give you answers based on where you have placed it. So let's take this tenancy dispute as an example. For situation, which is the S in scope, a client has come to a Nigerian lawyer with a tenancy dispute. The landlord has allegedly served a notice, but the client is unsure whether it is valid. Now, most people will just take only this and paste and ask it, with this information I'm giving to you, help me write so and so, maybe a notice or a demand letter, or help me. But we now move forward to writing the character. The character is you are acting as a Nigerian legal drafting and client intake assistant. What is your objective? Most people will just say, just go ahead and write for me. But the objective is, for me here, I will first say, before I do anything, I will first say, help me identify the facts, the documents and legal issues needed before any advice or drafting can go on. Then what are the parameters? You must make AI contained. It must be in a container. If not, it may even give you hallucinated cases. So parameters here can be: do not invent facts, do not invent cases, situations, or statutes, or citations. Ask for any missing fact, flag jurisdiction, limitation, notice requirement, applicable tenancy law. Though we are in Edo State, we can just say applicable tenancy law to Edo State. Procedural issues and authorities to verify. What is your expected output? It is, like I said, it is client intake assistance and a legal drafting. That is what you told it to act as. So the output here can be: give me client intake questions, missing facts, documents to request, possible legal issues that may come out of this, authorities and laws to verify, and ethical cautions. If you communicate with AI in this manner, you will always come out with a very good result. Then the verify method, let me just go through it. It simply means, verify simply means that you should verify the facts. After you have given your scope, your instructions to AI, your prompts to AI using the scope method, you then go higher, which is verify. You ask AI to verify the facts. That is what the V stands for. The E means to examine jurisdiction and procedure. The R means you should use only authoritative, verified, and cited Nigerian sources. And then the I means to identify gaps and risks. And then the F means to flag uncertainty. And then the Y means that you should produce outputs only after review and responsibility and confirm. That being said, we now look at the lawyer method. The lawyer method gives professional identity. So with the scope, the verify, and lawyer method, together, they show that AI may assist in legal work, but the lawyer remains a professional mind, the verifier and ethical gatekeeper. I want to talk briefly on the vein of AI in legal practice, the risk involved, case law, and real incidents that have happened. A serious lecture on AI does not sound like an advertisement for technology. AI has grave dangers. Some of those dangers can be reduced by careful adoption, but they cannot be eliminated by enthusiasm. The profession must therefore build defensive measures into law offices, courts, ministries, and legal education. One of the banes of AI is hallucinated cases and fake authorities. The most obvious dangers for lawyers here is hallucination of cases and authorities. AI can invent cases, citations, quotations, statutes, and legal principles, presenting them in a confident style that appears very authentic. This is not theoretical at all. I'll be talking about cases from other jurisdictions like Mata versus Bianca Incorporation, where lawyers in the United States were sanctioned after court filings that contain fake cases generated using ChatGPT. Also in Park versus King, the same thing also happened too, and then Ayinde and Solo and London Guru or Paringay. So please, whenever we are using AI, it's our duty as Nigerian lawyers not just to be direct, but to ensure that you verify whatever you are using. The prompt methods I gave, you verify, is our sure proof or our sure best to ensure that we don't get hallucinated cases. AI bias and algorithmic justice. The second danger is bias. AI systems are actually trained on data, and if this data contains historical prejudice or any form of imbalance or incomplete representation, the systems may reproduce or amplify those weaknesses. The danger is greater because the output may appear scientific, neutral, or mathematical. Bias becomes more dangerous when it bears the appearance of mathematics, like in the State versus Loomis. This matter happened in the United States and is very useful in this regard. It involved the use of the compass risk assessment tool at sentencing and raised concerns about due process, transparency, and the role of algorithmic tools in criminal justice. Although the Wisconsin Supreme Court upheld the use of the tool in that case, the controversy remains instructive for any jurisdiction considering AI-assisted decision support in bail, sentencing, parole, policing, or prosecution. A system that affects liberty must be transparent, contestable, and subject to human judicial responsibility. Another problem we will have with AI is falsification of evidence and deepfakes. The third danger is falsification of evidence. AI can create or alter photographs, videos. You can alter voices. We have tools like 11 Labs now. You can alter signatures, screenshots. This can easily be done with ChatGPT. WhatsApp chats, CCTV-like recordings, alleged consequences. First, false evidence may become easier to create. Secondly, true evidence may become easier to deny. A guilty party may claim that a genuine recording is a deep fake. A dishonest party may present a fake screenshot as authentic. The legal profession must therefore strengthen digital evidence protocols, chain of custody practices, metadata awareness, and forensic capacity. Another challenge will be tools that you are not paying for. If you subscribe to ChatGPT, your data privacy is more secure than when you just use the free version of ChatGPT. If you subscribe to Claude or you subscribe to Manus or Copilot or Gemini, your data security is more secure. None of your information will go out, except of course with the owners of such tools. Then we have automation bias and loss of legal reasoning. The model of unpredictability and misuse by wrong users. The same AI that can help a lawyer prepare a brief can help a fraudster prepare a lie. AI can assist in drafting fake legal notices, impersonating lawyers, creating false complaints. It can even generate forged documents. It can automate cyber attacks and spread legal misinformation. Even AI developers acknowledge that advanced systems can behave in unexpected ways under certain conditions. The legal profession must therefore treat AI governance as a permanent defensive duty, not a temporary training topic. Nigeria-specific risks. Nigeria faces additional realities, which include uneven access to expensive tools, AI tools, poor electricity supply, unstable internet, low digital literacy, cost technology gaps, limited local data sets, regulatory uncertainty, and overdependence on foreign systems that may not understand Nigerian law. If AI adoption is not carefully governed, it may widen the gap between large firms and small practices, between urban and rural courts, and between technologically fluent lawyers and those left behind. What is the way forward? Harnessing AI responsibility in Nigeria's legal profession. AI adoption is not enough. Responsible adoption is the goal. The legal profession must build defensive systems, ethical rules, regulatory frameworks, and Nigerian-ready legal infrastructure. For lawyers and law firms, there should be written AI use policies, mandatory verification of authorities, rules on confidential uploads, client data anonymization, senior review of AI-assisted work, approved tool lists, and training for juniors and support staff. No filing should be the law office merely because AI drafted it. The lawyer must verify, edit, understand, and own the work. For SANs and senior lawyers, that responsibility is heavier. They must set chambers-wide protocols, supervise juniors, AI-assisted grants, insist on authority verification before filing, and make it clear that AI is for preparation, not application. Professional excellence must not be lowered in the name of speed. For judges and courts, there is need for guidance on AI-assisted filings, training on hallucinations, deepfake awareness, digital evidence protocols, citation verification expectations, and safeguard for judicial independence. Courts may also consider requiring lawyers to certify that authorities have been verified where AI-assisted research has been used. The purpose is not to ban AI, but to protect the integrity of adjudication. For the Ministry of Justice, the GSC and policy institutions, the issues include public sector AI policies, data governance, cyber security standards, digital evidence capacity, procurement rules, training for law officers, training for judges and court staff, and clear institutional rules on what AI may and may not be used for. At the national level, Nigeria needs legal technology training, judicial modernization, infrastructural development and investment, support for homegrown legal tech innovation, continuing professional development and reskilling of young lawyers. Nigeria's National Artificial Intelligence Strategy and the Nigerian Data Protection Act 2023 show that AI and data governance are well matters of public policy. The legal profession must not stand outside the conversation. It must help to reshape it. The future of Nigerian legal practice and justice institutions. A glimpse into the future shows that legal practice in Nigeria is likely to become more structured, more digital, more data-driven, and more dependent on professional verification. Young lawyers will work with structured AI assistants, but must reason independently. Senior lawyers will supervise systems and not only people. SAS will use AI to navigate complex records and test arguments. It must not become an unverified research path. It must not become a channel through which confidential data leaks out of law offices and courts. It must deepen inequality. It must not deepen inequality. It must not replace empathy, conscience, advocacy, wisdom, or constitutional responsibility. The future of Nigerian legal practice will not be secured by resisting technology, nor by surrendering blindly to it. It will be secured by responsible legal professionals who can govern technology, verify its output, protect confidentiality, and align innovation with justice. In speaking about the future, Nigerian lawyers must not consume foreign AI tools. We must also build responsible Nigerian legal tech systems. Amicus advocacy is presented in this lecture, not as a replacement for lawyers, judges, legal databases, or professional judgment, but as an example of Nigerian legal workflow support. A responsible Nigerian legal tech tool should help lawyers take better instructions, identify missing facts, map legal issues, structure preliminary drafts, remind users to verify authorities, and protect ethical boundaries. It should not claim to be an AI lawyer. It should not give final legal advice without facts. It should not invent Nigerian law. It should not encourage users to bypass professional responsibility. Its value should lie in organization, structure, culture, and verification. For young lawyers, such tools can improve client intake and drafting discipline. For senior lawyers, they can support supervision and office workflow. For SANs, they can help organize complex materials. For law teachers, they can demonstrate AI literacy. For judges and justice institutions, they show why policy, training, and governance are now necessary. The message is simple. Nigerian lawyers must not merely wait for the future. We must help to build it responsibly. The role of stakeholders. The responsible integration of AI into legal practice cannot be left without individual enthusiasm. It requires stakeholder responsibility. The bar must be in ethical training, professional discipline, continuing legal education, and verification culture. The bench must protect judicial independence while understanding the realities of AI-assisted advocacy and digital evidence. The academy must reform legal education to include AI literacy, legal technology, data protection, cyber security, and digital evidence. The Ministry of Justice must treat AI as a matter of public legal policy, not merely office productivity. The JSC and court administrators must develop frameworks for training, data governance, and digital justice systems. Law firms must adopt internal protocols. Young lawyers must learn new skills without abandoning old discipline. Civil society, the media, and citizens also have roles to play. AI may affect justice, may affect access to justice, privacy, evidence, public trust, and democratic stability. Therefore, the governance of AI in the justice sector must be transparent, inclusive, and grounded in the rule of law. Artificial intelligence presents one of the most important professional and institutional challenges of our time. It offers speed, structure, productivity, and new possibilities for access to justice. It can help lawyers work better. It can help courts organize information more efficiently. It can help law teachers prepare students for modern practice. It can help ministries and justice institutions to become more data-driven, but it also threatens to introduce fake authorities, false evidence, confidentiality breaches, bias, professional laziness, and loss of public trust if used carelessly. The task before us is therefore not to praise AI or condemn AI, but to govern AI. The legal profession must build a culture of responsible instruction, verification, confidentiality, human judgment, and ethical accountability. We must train lawyers to use AI without surrendering legal reasoning. We must train judges to understand AI without compromising judicial independence. We must prepare law students for a profession where technology will be present in almost every area of practice. We must strengthen Nigerian legal databases, official sources, court technology, and local legal tech innovation. AI will not replace the conscience of the lawyer. It will not replace the wisdom of the judge. It will not replace the dignity of the courtroom, the discipline of legal reasoning, or the sacred obligation to do justice according to law. But AI will test whether the legal profession is ready to reform today in order to secure tomorrow. The responsibility is ours, and the moment is now. The future of justice will depend substantially on the courage, the discipline, and the wisdom with which the bar, the bench, the academy, and the Ministry of Justice, the JSC, and all justice sector stakeholders respond to this new frontier. I thank you all for your kind attention.
This presentation is tight, is packed, it's an intellectual paper, and it's a technological experience. She deserves a wonderful, round of applause. She's a colleague. She has done really well, done justice to the paper. Thank you very much. What a very great way to start today. With the kind permission of the presiding judge, Federal High Court, my Lord, we appreciate you. The Lord has given us His gracious leave to interrogate this paper. The paper started before my Lord came in, and with profound respect to the minority lords that are already seated, and indeed the body of Senior Advocate of Nigeria, the former AAG, the INEC rec, other protocols that we will take pretty much later after this. We want to interrogate this paper via questions and comments, and that will take about 20 minutes as graciously approved by the Lord. So please let us quickly do that. Microphone will go around. Where's the microphone? We go around. Any questions concerning this paper? Questions, interrogation, comments, addition, and all of that. Who is holding the microphone, please? Please, sir. The speaker, please. The speaker, please, may you step forward. Sorry, sir, just a minute. The speaker, please step forward. Please have your seat very close there, and so you can take note of the questions and comments and respond appropriately. Yes, please, sir.
My name is Sunday Sawaru Abidede. The issue with AI has just been fully diagnosed by the presenter of this topic. But the issue with AI is that there is danger, as outlined by the presenter, it will give you authority of, let's localize case of academy and academy, and it will give you wrong citation. So if you don't go to your law reports and check properly the correct citation, and if you take it lazily, you may put that on your brief or your final written address, only to find that you have misled their lordships when they are doing research. They will also give you a term on an issue. And if you don't go beyond what they have presented to you by going into your reports, you find that the AI will take you to worry whether you are going to Lagos. So in this respect, I want the presenter to guide us, although he told us that we have to domesticate the and restrict the AI to what we want. But in spite of that restrictions, the AI still give us misleading information and textual issues. Thank you.
Thank you very much. More questions, so please, can we manage time by getting the questions or comments come quickly? So, over there, please. I think we take all the questions together, 4, 5, very well, that will be available, and she will respond to all.
I'm more popularly known as Doc K. Permitted to stand on the existing protocol. AI as a tool is very good, but the question is, what is our defense against AI when it starts issuing wrong commands? That's one. And how do you tame it when, because like social media now, before it came, or when it came new, it was very good, but now you can train your children and social media will help you train them better. So how do we tame AI when it gets to that stage? And 3, is AI at its final stage or is still developing? Thank you.
Thank you. Any more questions, comments, please? Yes, please, here. Oh, sorry. Bring it forward here. After we take you. Available. Just be ready.
Thank you very much. I want to really commend the presenter of that paper. I found it very useful and all-encompassing. What I would want to suggest is that we should think of introducing this kind of learning early to the students in the university and at the law school, because I have a daughter in the law school now, and I know that they are relying a lot on technology, even in reading. So it would be important for them to know early enough how they should apply it. You are talking to many people who may not even know how to use the AI like we're talking about, are interested. But I think we should be talking to the people who are coming up in the universities and in the law schools. It will be very useful. Maybe the body of lecturers will want to push this and it becomes part of their curriculum in the Council of Legal Education as part of curriculum for legal training, please.
Thank you very much. Available, please. Available, please.
My Lord, to your leave, sir. I must first join the array of lawyers to commend the paper presenter this morning. In fact, she has displayed intelligence. In fact, she's going haywire, she's going high. In verifying information we get from AI, I think that I'll just suggest, because I paint a scenario. I was doing a research. I just wanted to play with AI to see how effective or assured the results I get will be. And I went to, I logged in, I tapped in authorities for extension of time to 5 minutes. I just took that as a case study so that I see the results I get. In fact, I got Idudun and Okumaba. And I said, I have always read Idudun and Okumaba. I don't see any of the decisions tending towards extension of time. So what did I do? I went to take the hard law report just to verify the information I have gotten. I looked at all the editors' ratio. There was nothing like extension of time. I read the hard judgment. You know, it's not always safe to rely on editors' ratio. I went to the real judgment. I read through again and again. I didn't see anything extension of time. So I told myself, when you are using artificial intelligence, be very careful, because you may just supply a wrong authority for a principle. And you know, my lords are very careful. My lords may look at the authority you have cited, look at the issue of ground, and see that they are not related in any way, so that we don't fall victim of the discussion of yesterday. You file a wrong or a case at the Supreme Court when you are not ordinarily supposed to file, you get slammed with cost of 10 million naira. So that time does not come when my lords will look at the authority you have cited, very, very wrong authority, and they slam you cost.
Thank you. The point is made. The point is made. Please, we have some hands over there. Can we make it brisk?
I stand on existing protocols. My name is Paul Ibuke. First, I also want to commend the presenter for a very good presentation. My question is, you talked about talked about protection and confidentiality. So, in using AI, how do you manage data privacy and protection of the individual? That's my question. Thank you very much.
Thank you. The next, that was somebody, okay. Coming to you, please. Quickly, please.
Thank you very much, sir. I stand on the already established protocol. My questions or contribution to food. Firstly, one of the advantages that AI has brought, mainly for some of us in the office of the state government, the chambers of the Attorney General, is that if you prepare the document these days and it has to go to the desk of the HEG, it is a major requirement now that you must first brief him on the fact of the cases. The days when you just cite cases and say the court heard, they will tell you, have you studied the case, have you these principles, all of that. So the advantage, because he himself is aware that AI is doing a lot of wonders, and because of that, that has brought the need for us to individually go through cases that you are citing. That's one. Now, the other area I'm going to look at is, luckily I believe we have law teachers at the of the university. While I was doing I'm still doing my PhD thesis, and at the preliminary stage, one of the issues I encountered with the supervisor was your thesis presentation. Our concern was your English are so smooth. You know, most times when lecturers sit to look at your work, they are looking at your use of grammars. They are looking at the use of your grammars, your apostrophe, your comma, your full stop. Basically, they are concerned with forms and not really substance. So, if they want to check if you did something, they check is there comma here. So, when the person just saw and saw that the English was so smooth, he said, "This is AI," and because it's AI, you didn't do this work. So, and my concern is, I think we need to understand that the future is AI. The future is AI, that's a fact. So if you are sitting as a supervisor and the only thing you think you want to contribute to the work of your students is the use of those stuff, tenses, you may have a challenge. So there is a need for us to sit down, accept, embrace, even the academics, that there is a need for us to embrace that AI is the future. So you have to pay more attention to issues that are more important than just looking at those things, because AI have to solve such problems and the use of terms and all those things. Thank you, Kevin.
Thank you. Let's do 1 minute, please, each. Can you move forward? Perhaps the last. Please. please, pardon us. Oh, Milord, sorry, please, can you pass it straight over to Milord? Honorable Justice Azebel, please. Milord. Thank you, sir. Okay. I get it, but I enjoyed the presentation. Well, my advice is this: we must be extremely careful when it comes to this AI. If it makes you lazy, that's number one. That is why I'm going to use at that level. At that level. And moreover, we have not been taught thoroughly. We need to know so much about it. I know later it will help us, but let us take this slowly. Thank you.
Well, if I may, I think that there is a large body of knowledge now available, and we seem to live in the belief where there is a wide, if you like, an explosion of knowledge, several things to know, and the computer helps us to organize. But I think we should be careful, like the learned brother said, so we don't outsource our intelligence to AI. That's the danger people fear with unrestrained embracing of AI. AI is a tool to recognize, tool for research, principally for lawyers. So that's why somebody said when it returns results of research, you verify yourself. But the place of the human intelligence shouldn't be, what's the word now? Deficit. Thanks for, thank you. I'd like you shake your fingers. We shouldn't, because these things should be driven principally by us, the human mind, as it were. And this fear that if we outsource everything to AI, before we know it, we will lose total control. That will be fear. But I don't think in the world where we live now, we cannot have some recourse to AI as a tool for research to make us, help us to organize the body of data that's available to them. It's increasing. But the point is, we must be restrained in our application of these AI tools. I think that it should reside in us. The ideas, come principally from us. We use them as aids to guide us in the direction that we should flow. I think that's why we must be careful where we go about these tools. That's my contribution. Thank you.
Thank you, Lord. Please, Vice Chair. And now, please, will be the last comment or question.
Good morning, members. My name is Itoha Ekama. My contribution is from the general consensus is the fear of getting into AI, using AI, the errors that comes in and others. But I also align myself with the speaker, my last colleague that spoke on this issue. The truth is, the future is AI. This lecture, I'm sure she's going to talk about it. The lecture is just like a summary of what AI is and how it helps us. But the truth is, there are trainings that must be carried out. We have to train ourselves. It's like somebody from primary school practicing law. It's not possible. You need to go through trainings. And there are apps, I think, that helps with accuracy, not just the normal Meta and Chat GPT. So there are trainings that has to be carried out, and I think that's where, whether for the bench or the bar, it has to come in to train us on how to go about it. Individually, I know she does training. I've scheduled to have mine very soon. I think the bar can also schedule, whether for older lawyers, younger lawyers, and others. There are apps we subscribe to yearly that can help us with accurate data information. So I think it's not pushing, it's like saying that if you enter a vehicle, it may have accident. So let's all trade. We don't need to trade. Let's learn how to play safe. Thank you.
Thank you very much. That is the last. And maybe please familiarity to add that in accordance with our very revered practice in growing ourselves in the profession, continuous learning, education is part of our thrust. Just like we may not get the equation balanced through quadratic equation, and we are checking it, so it's AI. I think it's continuous training, continuous schooling ourselves with these tools, emergence of new technology. I align myself greatly that AI truly is the future, and we must train and school ourselves to it without jettisoning our natural intelligence. Now we will hand over the microphone to the speaker. Please step forward to let her come forward to the podium, please. Yes. To answer, I have a microphone for you here. Please, can you help us do 10 minutes? Thank you. We'll put our hands together again for Rachel.
Thank you so much. Your questions and contributions really show that most of us in the house are not really new to artificial intelligence. I will start by appreciating my dogs for their insightful contributions, our professors in the house, and our very esteemed senior colleagues. So let me start with question 1. AI still gives cases that are not correct. That's very true. And then what is the solution to that? You know, in the course of giving my paper, I said that there is a proper way to communicate with artificial intelligence if you want to get the expected output. And the best way to discuss with AI is the proper communication known as prompting. Prompting simply means the act of giving instructions to artificial intelligence, and then it then gives you a feedback that is worthy of what a lawyer should spend their time on. And there are 3 stages of giving information instructions to AI. And the first stage is known as the scope, S-C-O-P-E. I did that coinage. And scope simply stands for, the SDS stands for situation. You must tell the AI tool you are using the situation. And then after you explain the situation, and then I use a tenancy dispute as an example. I said, for example, for situation you can say, a client has come to me, to a Nigerian lawyer with a tenancy dispute, and the landlord has served a notice, but the client is unsure whether it is valid. That is the situation. Most lawyers will just stop there and they say, give on that instruction, maybe draft this or give me this. But the next thing is the character. AI must understand what it is for you at that moment. To a lawyer, AI is a legal assistant. To a medical doctor, AI is an assistant in his profession. Same too with someone who is a civil engineer. So it's like an Weber. You have to make it have a character, assume a character in your instruction. I know this requires trainings, but this is just the best way to communicate with AI. So for character, still on the tenancy landlord tenancy disputes. I've talked about situation, but character will now say, act as a Nigerian legal drafting and client intake assistant. So once AI now knows that, oh, I'm actually acting as a legal drafting and client intake assistant, it now goes to its database to search for the different data that may have been uploaded into its large language model as regards what legal assistants do or what client intake assistants do, or people who are into drafting do, or legal drafters do. And then from there, it now starts planning how to answer you. Then the next thing is the objective. When you are communicating with AI, still in your instructions, still in the prompt, still on space one, which is the scope, AI must have an objective. So here, my objective is that AI should help me identify the facts, the documents and legal issues needed before any advice or drafting can go on. So because I've given a situation to my AI, I've given it a character, I've given it an objective, the hallucination rate here will just be around 5 to 10%. But then it now gets better. When we now talk about the parameters, we have to keep AI in a container. If not, like I said, it's an Amweba, it will just float everywhere. What are the parameters? It may include that, okay, in my case I said you must invent any facts, cases, statutes, or citations. With the proper use of AI tools, you can actually do serious deep research. I've been opportunity to do lots of deep research using AI, and I search through thousands of websites in seconds. Why? Because of the instructions I give AI. And I don't return with hallucinated cases. I don't return with hallucinated citations. I don't return with verbose principles. I return with real data that you can use as a lawyer. You can defend anywhere and claim as your own. Because I gave it the right situation, the character, the objective, the parameters. Then the expected output, you must understand what you are expecting from it. Because it will just give you things that will make you keep floating. So in my case, I said, give me client intake questions to ask my client. Give me missing facts that my client needs to tell me, documents to request, possible legal issues, authorities and laws to verify, and ethical questions. If you use scope for your AI prompting or instructions, you will not go wrong. Though we are human beings and even human beings fail, but the tendency for AI to hallucinate when it's under the strict guardrails is around 5 to 10%. Then we now move to the verify method. In verify, after you are done with the output from scope, this SCOPE, we now send it back. We just send it a prompt and say, now verify your facts. The verify here, the V simply stands for verify, the E stands for examine, the arrow stands for requiring reliable sources, and then the I in the verify means to identify gaps and risks in the answers it has given to me. The F means to flag uncertainty, and the Y means to yield only reviewed output. So verify is the shield against hallucination. Once you are done giving your scope instruction, you then impute verify, and with verify there will be no hallucination to a large extent. I won't say no hallucination because even human beings make mistakes, but the machine hardly makes mistakes when they are given the right parameters. Then the lawyer method. The lawyer method is actually, it gives you professional identity. That's where my reasoning comes in as a lawyer. Can I represent this work? Can I take this as a process and file in court? Can I put my signature on this? So you have to now put in your cap. AI cannot human intelligence cannot be jettisoned because of AI. But we must ensure that we don't neglect the use of AI. If not, we'll just be behind the trend. Because AI is actually taking over. So our defense when AI starts issuing commands, that's a very great question. Because as I speak to you, there is this new model on Claude. Claude is one of the tools that lawyers have used overseas in the US and UK, and has really given lawyers cool edge when it comes to drafting legal reasoning. With Claude, you can organize your projects better. But Claude recently, their mother company Anthropic recently released a model known as Meteors. And they are so even the company, they are afraid about what Meteors can do. Because with Meteors, you can actually scrape website, you can find out the issue with their code and you can just do a 0 day on them. What are the implications of this? Claude and Tropic, because they don't have what it takes to control these particular meteors, they decided to make it a project that will be used by just selected companies. Because if it falls into the hands of the wrong people, it can be used as a weapon against the delivery of justice in our case as lawyers. So yes, what my learned senior said is very correct, that AI can actually start issuing wrong commands. We have had situations where I give prompts to AI and AI does not listen to me, it just keeps firing. And so we have to, that's where training now comes in. If you are not trained on artificial intelligence and the use of AI tools, you end up coming out with results that are not flawless. Come out with results that will question your integrity. And then we should also know that currently there is what we call the dark web. And there are lots of tools that cannot be controlled by even those who created them. That is the era we are in currently. So serious training, serious research needs to go on. Then, another thing I was asked is whether AI is at its final stage. No, it is not. It is still developing and it will get better than this. Currently, we are using AI tools that are borrowed. But very soon in Nigeria, if we can actually invest in our own, we will have a lot of AI tools that are adapted to our legal practice here. So very soon we'll see such coming up. In other countries, West African countries, they are already adapting. Their legal systems are already adapting. But then Nigeria, we are coming up. Then we talked about, I was asked about AI and AI teachings being incorporated in schools and in law schools. That would be a very good initiative if it is accepted, because we have to catch them young. The world is going digital and we cannot be left behind. So my lords and distinguished seniors present, lawyers present, I want to finally appreciate you for your time and your kind attention in giving my paper and then in your quality responses. Thank you so much.
Our dear wonderful colleague, great academic, I dare say, Adesiwa Celestina Alberti Esquire, deserves a wonderful round of applause again, please. Great presentation and great response. At this point, Milo, with your kind permission, I humbly seek your leave to start the morning session, the first session properly. So may I seek leave of Milo to Lord, I'm coming to you. The shop is not quite now. I'm basically going to please start this session. May Lord, the presiding judge, Federal High Court, Benin Judicial Division, Honorable Justice B.O. Padri, Dublin as Chairman of Session today. The noble lords here present, appreciate so much your lost noble lords yesterday fully. The learned Attorney General, Honorable Commissioner for Justice at the State, Professor Roland Otabu, Senior Advocate of Nigeria, was with us yesterday and indeed informed us that we'll be out of jurisdiction and we're expecting that it will be represented by the Solicitor General Stephen Okoro Esquire. We are expecting the national officers here present, the chairman of the Lion Bar, the Only Bar all over the nation, distinguished body of Senior Advocate of Nigeria, Chairman Planning Committee, my dear namesake Samuel Atoy Esquire, doing great job putting this law week together. ESCO members of the Lion Bar, particularly by Chairman Toa Ekama Esquire doing a lot, and the chief scribe of the bar. I'm talking about Chris Otasowe Esquire. Great academics here present, and in particular, the DVC admin at Benin University, Professor O.G. Izebuwa, and senior lawyers, leaders of the bar, various professional bodies and their leads here present, respected colleagues, the press, security, distinguished ladies and gentlemen. I want to appreciate you very, very specially, and particularly some of our distinguished seniors who have come in a few minutes before 9. And I've waited patiently, Lord, to have this session started. I want to appreciate them, want to apologize on behalf of the planning committee that is not for, we cannot take your presence for granted. We apologize for starting a little behind schedule. We thank you so much. This session has to deal with a commanding topic, a topic that is dealing with our electoral existential issues in progress right now. This nation passes through a phase of leadership enthronement and being midwifed by the institution that has been set up to do this great job. And a lot is going on in the electoral ecosystem. Primaries, the election proper that we expect 2027, therefore, the topic to interrogate for this session may not have been better couched than the one here, electoral reform and democratic consolidation in Nigeria, interrogating the new legal framework. And to chair this session properly, we have the distinguished presence of the Lord, the presiding Judge, Federal High Court, Benin Judicial Division. My Lord, with your kind permission, we want to do your citation. My Lord, we are not asking the Lord to stand on, but when we have been citation, so we do stand the Lord, we respect that. Thank you, Lord. Our distinguished guest is a seasoned jurist of the Federal High Court of Nigeria with a judicial career spanning several decades across both the magistracy and the Superior Court system. His lordship began his judicial service in the Oyo State Judiciary, where he rose through the ranks of the magistracy to senior positions before his appointment to the Federal High Court bench in 2009. Since Milord's elevation, he has served in various judicial divisions of the Federal High Court, presiding over a wide range of civil, criminal, commercial matters, and contributing significantly to the development of federal jurisprudence in Nigeria. His lordship's career, judicial career, reflects steady progression, institutional discipline, and long-standing commitment to the administration of justice. We have the very singular honor and privilege to humbly present our chairman of session, my Lord Honorable, the presiding judge, Federal High Court, Benin Judicial Division, Honorable Justice P.O. Badri. That class is starting and that over. We can do it better. Thank you. Please. We have, thank you very much. The Lord, we appreciate you, indeed we love you. Thank you, Lord. We are coming on a great expert in this area, a great son of the soil, Edo State, who has done this state proud nationally and internationally. We have the privilege to have him, a distinguished practitioner in the profession, a senior one at that, a former Attorney General, Honorable Commissioner for Justice at the State. Our distinguished guest to interview this topic today is a highly respected legal practitioner, electoral governance expert with over 4 decades of professional experience spanning private legal practice, public service, and institutional leadership. Called to the Nigerian Bar in 1982, he obtained his legal training from the great University College Wales and Abbaswell. Did I get that right, sir? Pardon me. The pronunciation is coming with a lot of stables wobbled together. But let me try. Abaris, and later, the University of Benin, building a strong foundation in institutional and public law. He served the Independent National Electoral Commission (INEC) in several senior capacities, including Director of Legal Services and Director of Voter Education and Publicity, where he played a central role in electoral administration, legal advisory functions, and institutional coordination of national elections. Following his service at INEC, he was appointed Attorney General and Honorable Commissioner for Justice, Edo State, where he contributed to the administration of justice and legal policy development at the state executive level. Widely regarded as one of Nigeria's leading voices in electoral reform and democratic governance, he has contributed extensively to policy discourse through lectures, advisory roles, institutional engagement at both national and international levels. We have the humble privilege to make welcome big uncle of our time, thoroughbred professional, multidisciplinary personality. Please make welcome Oluwole Osaze Usi Esquire. And we put hands together, loud attention with you. That clap can go on till the seat. Thank you very much. And because the learned Attorney General and Honorable Commissioner for Justice took leave of this gathering to go out of jurisdiction, we still nonetheless permit us, my Lord the Chairman, to read his citation and introduce the person representing him. Thank you. Professor Roland Otaro, Senior Advocate of Nigeria, is our distinguished guest and a former Senior Advocate of Nigeria and a distinguished academic and a practitioner of the law with decades of experience in litigation, arbitration, and constitutional law, called to the Nigerian Bar 1986 after obtaining his LLB from the University of Benin. He has built an eminent career spanning private legal practice, academia, and public service. He is a former managing partner of leading legal chambers and has served in several leadership and advisory roles within the Nigerian Bar and the wider legal profession. In recognition of his contributions to legal practice and jurisprudence, he was elevated to the rank of Senior Advocate of Nigeria. I thought you were going to clap, so here's over there. Thank you. He currently serves as Attorney General and Honorable Commissioner for Justice at the same where he heads the State Ministry of Justice and oversees legal policy formulation, prosecution services, and justice sector administration. We are honored to make welcome the learned State Professor Roland Otaro, Senior Advocate of Nigeria, here represented by partner at Preston and Gray. Benin City here, they have chambers across the nation. Please make welcome our amiable looking dear friend and brother, Akibe Oserabo Esquire, representing the Attorney. And because of the arrangements here and there, he doesn't have his paper quiet, but we know that he's capable, he's into this field, and this sector we are interrogating, he interrogate the paper. Thank you very much. Another round of applause to the gentleman, my colleague. Thank you. We have a great elder who is also taking the place of our dear learned self, Kingsley Obamange, Senior Advocate of Nigeria, who is unavoidably absent for very essential commitments out there. But here represented by a great elder leader at the bar, feeding us with the ethics and professional climb through the ranks. He's a pastor of Church of God Mission. As a matter of political alignment, he has a bias to the PDP, political party platform, and he has been there since 1998 to 2023. And he's a great practitioner in the profession, won several high-power cases, and of course leading us in the profession to the high heights. Please make welcome our dear elder at the back. I'm going to let you sign for Esquire. We like fly. We put your hands together for the elder. Thank you very much, Elder. Thank you. Another round of applause for the Elder participating in the session. It could have been, not that it's not possible, let me use the word appropriate, to have discussed this topic without making do with the very presence of the person we are introducing now. It's like saving the best for last, because we know that he has answers to several questions that we may pose in this topic we are interrogating today. So we are indeed privileged to have the very distinguished presence of the INEC Rep Edo State. Please, we are taking your citation, sir. Thank you, sir. Our distinguished guest is a legal practitioner, journalist, public administrator with extensive experience in the life of governance, democratic reforms in Nigeria, called to the Nigerian bar in 1995 after obtaining his LLB from the University of Calabar. He also holds a master's degree in human rights from the University of Sussex, United Kingdom, and a background in mass communication. Admire you, sir, and I know why, for a reason. He began his professional career in journalism and civil society advocacy, working with the Nigerian Chronicle and later with Action Aid Nigeria, where he spent over a decade contributing to development and governance-related initiatives. He also distinguished himself in media practice, earning the Nigerian Media Merit Award for Columnist of the Year 2004 for his contributions to public discourse. I thought we were going to clap, please. Let's agree, in public service, he was appointed Resident Electoral Commissioner of the Independent National Electoral Commission INEC in 2017, where he played a key role in the administration of electoral processes, including the conduct of the 2019 general elections in Rivers State. He is widely respected for his interdisciplinary contribution to the law, journalism, and electoral governance in Nigeria. Indeed, a man of multidimensional capacity. Make welcome the Resident Electoral Commissioner, INEC Edo State of Bong, Efa, Esquire. Please, possibly standing ovation for this great man. Well, bring the well. There is the rank of youth leadership, permit me to add, that we may want to do. The Lord the presiding chairman, please, we seek your leave for about 5-7 minutes for my colleagues to quickly talk some introduction as a matter of respect for those that are here. Osari King, please, can you run through that, please? Want to acknowledge senior lawyers, academics, people who have always honored our call, Law Week and other activities, proper that we acknowledge them. Osari King is my co-compare. Please, your hands together for him as he runs through some of this.
Thank you so much, Mr. McAvey. My lords, let us seek here present. May I adopt the already existing protocol. Quickly, I will recognize some very senior lawyers and respected personalities we have in this hall this morning. May I recognize the presence of the Pathfinder, the chairman of the MBA Benin branch, Mr. Idemudia Iradia Osifo. Please let's put our hands together for our chairman. Our chairman and his team, they have done so well. Thank you, Mr. Chairman. May I also recognize our very own Leonard Silk, a man who needs no introduction, is our own K.E. Mosian Estate. Please a round of applause. May I also recognize the Vice Chairman of the branch. It's no other person for our own gorgeous Mrs. Itohan Ekama. Please a round of applause. Distinguished ladies and gentlemen, we also have with us the treasurer of the branch, Mrs. Joy Obasi. Please let's put our hands together for her. With the kind permission of the chairman, I apologize, we have our laws present here with us. Please, may I recognize the Judge of the Edo State High Court, Honorable Justice V.O.A. of Yahweh. May I also recognize our very own Honorable Justice A.T. Momodu. God bless you, sir. You're welcome. Distinguished ladies and gentlemen, we also have Honorable Justice W.I. Azmi. Okay, my Lord was here, I think he stepped up briefly. We appreciate the presence of my Lord. We also have with us Honorable Justice R.A. Ubebon. Okay, let's put your hands together. My Lord was here with us, just stepped out. Thank you very much. We also have one of the key persons in the executive committee of the NBA Benin branch. No other person but the secretary of the branch, our own Mr. Christopher Otasuye. You're welcome, sir. Distinguished ladies and gentlemen, may I especially welcome our very own, in fact I call him my father. He is our Right Honorable Pascal Ubome, the Ominimi. If you like, you can call him the Ominimi of the universe. We are glad to have him with us this morning. May I also recognize the presence of Professor Joe Odion. He's here with us this morning. Okay. Distinguished ladies and gentlemen, we also have Mr. Ima Tairu Ojekwai, former chairman of the branch. You're welcome, sir. We also have the former chairman of the branch here this morning, our own past chairman, Eddie Asenogwa, the old of the branch. You're welcome, sir. May I also recognize our very own David Maduku, the former secretary of the branch. God bless you, sir. Quickly before, may I also very well recognize the chairman of the Lobbying Planning Committee, a man that has been doing so well. In fact, he has featured in several lobbying committees, and from what he's doing with this lobby, we have no doubt that you are doing very well. You have the capacity and you are well equipped for the job. Please let's put our hands together for our own Sam Ator. God bless you, sir. And of course, we have the alternate chairman of the Lobbying Planning Committee, Mr. Ike Fidelis Elema. We also have the secretary of the Lobbying Planning Committee, our own OTOKK. God bless you. And lastly, may I recognize, before I hand the mic over to my brother, Theophilus, may I recognize Mr. Elijah Itzel Wilkie. God bless you. Thank you very much.
Thank you, Sadiq. Beloved Chairman of Session, beloved here present, may I humbly maintain the same greetings as earlier established. It is my singular honor to also introduce a number of very important personalities in our midst today, not in any particular order. I have here, it is my pleasure to introduce, to recognize Mr. Michael O.C. Amer. He's the Secretary Judicial Service Commission and You're most welcome, sir. Thank you, sir. We also have some very distinguished worshipful magistrates in our midst. Permit me to introduce, to recognize the presence of His Worship, Esther Aimofume. You're most welcome. Worship also with us. We have His Worship, Endurance Monsenigye. You're most welcome to worship. A senior lawyer of the bar has graced our occasion. Mr. Baltoye Esquire, a welcome, sir. It is also a singular honor to recognize the presence of S.O. Aguimede. You're very welcome, sir. It is also my singular pleasure to recognize the presence of the former chairman of the Owan East local government. Saw him not too long ago, Dr. Victor Obiosuma. He was with us not too long ago. My senior colleague, both at the bar and in matters of media, he happens to also be the lead rapporteur for today. I saw him a few seconds ago, Douglas Ogbankwa, past publicity secretary, NBA. Thank you for being with us. We have C.U. Okumbo, the Assistant Director, High Court Registry, I believe retired. You're most welcome. And I'm very sure that recognitions will continue as we go on. I will hand over the microphone now to my colleague, Mary Tonya, to continue. Thank you so much.
Permit me to greet everyone seated here respectfully. I would like to recognize the presence of C.O. Edosa. I also would like to, you're welcome, sir. I would like to recognize P.O. Oselenka for giving the pronunciations wrong. I would like to recognize Kes Odige Esquire. I also like to recognize Titus Owo Otoru. I'd like to recognize Kristen Omotshola, that's the chairman of NBA Teleco. I'd like to recognize Emmanuel Okosu, past publicity secretary. Thank you all for coming.
Thank you very much. We are sorry that we needed to do this, and thank you for your kind permission and time. Stella Aide, Edo State Coordinator, African Women Lawyers Association, you are here with your team. Thank you, Mr. Chairman. At this point, Mr. Chairman, we would prefer to, if you are comfortable sitting or coming over here, to do the Chairman's remark for the opening of this first session, and Mr. Chairman, the Director, coming the running of the session. Our hands together for the
With the kind permission of the senior members of the bar, the entire members of the bar, my lords, co-panel discussions, I came in very late because I was otherwise engaged in an official engagement, so I had to cut it short, not to be content to the bar. So. Session is no other topic would be much more relevant than the topic electoral reform and democratic consolidation in Nigeria, interrogating the new legal framework. The following form the area of focus: the Electoral Act 2026, an instrument of democratic consolidation or democratic reversal, innovations and gaps in the new Electoral Act, judicial interpretation of electoral laws, and strengthening institutional independence, INEC, tribunals, and all that. Our discussions here are past Attorney General of Edo State, Oluwole Osaze, who's the most welcome. Last person is Mr. Ahibi Oserogo, the most welcome. Next person is Mr. Osa Yombo. Sorry for not pronouncing it very well. I'm just 3 years old. Yeah, I'm in this position. Over time, I'll get used to it. The next person is the INEC, Edo State INEC Presidential Electoral Commissioner, Mr. Ogon Efo. You are most welcome. My duty here is very simple. I am a glorified timekeeper. I know most of these topical issues we will later interface between ourselves and God. I will only summarize whatever they say. My own mind, my own opinion is very deep in my heart. So, without taking much of your time, each of the discussants will be given 10 minutes. So as a glorified timekeeper, I'll give them 10 minutes each. Once they are about to exceed the time, I'll find a way to draw it close. And so, gentlemen, I'll call on the first speaker, the past Attorney General of the state, to shed more light on those areas we have just talked about. The Electoral Act 2026, Instrument of Democratic Consultation and Democratic Capacity, innovation and gaps in the new Electoral Act, judicial interpretation of electoral laws, and strengthening institutional independence in the INEC and tribunals. Without breaching Section 36, I'll give you 10 minutes.
Thank you so much. My lords, co-discussants, senior advocates, and their dear colleagues, I have 10 minutes, so there'll be little or no time for anything else. But first, I must acknowledge and thank the organizers for giving me feet to make this presentation. I'm also sure that I'm invited here as a former Attorney General or as a former Director at INEC. But whichever capacity, I should try and outline. I'm not here for a lecture. I'm here to be more or less a lead discussant, to provoke questions, guide our minds and everything else. The NBA, as far as I'm concerned, should be at the forefront of everything to do with electoral reform. But let's start with the most elementary part of it. How many of us here, I guess everybody has a PVC, how many of us here know our councillor? How many people know their councillors? 3 hands, and the minimum doesn't count because it's a question. 4 out of maybe 200 people. How many know their local government chairman? The same thing, less than 10 people know their local government chairman. Now, this, in democracy, this is the very base from where we start from. We know our president, we know our governors, but these are at higher levels. In a democracy is sovereignty is in the people. You tell them, the smallest, the work level, the councillor is the smallest person we should know. I don't know how many of us know that there's an election coming up next month in this state. There is a local government election, most of us are not aware of that. We don't even know our current chairman or councillors. How many of us can possibly know who the contenders, who the candidates are? So, this, I hope, will provoke discussion and provoke understanding of the process. We must begin from the very beginning. It has become customary, as we discovered yesterday, that it takes, at each election cycle, we now review the framework. We tease out what the issues are, what the challenges are coming from the previous round or cycle of elections. And since in the pre-1999 state, there were decrees for every state, the decree for transition to civil rule, there was a decree for the presidential, a decree for local government, a decree for regional parties, a decree for establishment of INEC, and all that. That consisted of a legal framework. But now, basically, our legal framework is a tripod. A tripod of the Constitution, which is a broad outline, establishes the office, establishes INEC, and broad outline of how people can be elected. Then the thank you very much, John. I was hurrying because I was told 10 minutes, but my time has been extended very graciously. I'm very grateful for my Lord Chairman. So, there's basically a tripod. But as the lead given by my Lord and the organizers of this, judicial interpretations are an essential part of our legal framework. Judicial interpretations and I'm so happy, I think I'm not to here because two of the panelists here are my protagonists in living premise. The cerebral here has been persuading me for the past 3 or 4 years. He took me to the Federal High Court, he took me to the Federal High Court. We had good things there, but just before he came. And then fortunately we got judgment, but the judgment was that go to the State High Court. So we're still on, and we still have to adopt our processes in that matter. As I got there, used to be on my side. Later on, we got to the other side and challenging me so often. So the only friends I have here are my Lord who protect me, I'm sure, and a founder who I've known for more than 10 years because I was a director or a commissioner in Benin and very well versed. And what gaps I have here, I'm sure he will feel it. But I also see protection from this side, from my lords who are very well versed and who have continuously, I think, just over we have done 3 cycles, more than 3 cycles of presiding in the election petition tribunal. This is model. So I'm protected. There will be gaps and there are many gaps in my presentation. I'm sure they will feel it. And of course, Ken Esquire, who used to be my lawyer and I was on the same team. If you go to Anambra, it's for ACTA. If you go to Delta, it was for PDP. And I guess APC now. If you go to Edo, it's APC, PDP, or NDC, or ADC. I'm not so sure. So we have a rich history. And I'm sure when the organizers were doing this, they did not know the entire relationship between us. The Attorney General was my lawyer when I was in it. I wanted to do some cases for the so he's there. Mr. Vanga is there, they don't know that we have worked together. So I think this should be enriched by their contributions. So basically, but is there a new legal framework? I am constrained to only discuss the Electoral Act because the Electoral Act for now, out of the tripod, the Constitution has not been amended. There are other bills, and I'm sure the ladies here, the gentlemen is here, we're very worried. Should we not have amended the Constitution? For example, there's a bill called National Assembly. It's been there even before the electoral bill went into National Assembly 2024. Special seats for women. And I'm a he for she, I support that bill, but I'm not going to discuss the merits of that bill because that probably will take us too long and we'll be beyond this. So let us be careful about this. That because there are several constitutional bills. There's a bill for independent candidacy, for example, but obviously that has not come to fruition yet. I think it's still the second reading or something like that. There's a bill for the establishment of the Electoral Offences Commission. There have been bills right from the waste panel to Unamani panel and private members' bills for the establishment of the Electoral Offences Commission, but that has not come to fruition, so we're not going to be able to discuss this. So the Electoral Act is the only part of that tripod that has been touched. But there's a third part of the tripod, which is the Internet Regulations and Guidelines. And after I prepared my discussion notes, I now got a copy of the regulations and guidelines for the conduct of 2027 elections. It's less than a week old, really fresh from the meat. Less than a week old, so I'm not going to be speaking about that. It was to bring it in line with the requirements of the Electoral Act of 2026. So when the Electoral Act came about, in 2024, a bill was introduced to the National Assembly to amend the Electoral Act of 2022. As I said, apart from 2019, each election cycle brings a new bill arising from shortcomings. And what are the shortcomings or what perceived shortcomings of 2020? What are the main things? And I'm sure all of us have our opinions, but basically I teased out 3 or 4 items from that. The first one was IREG. IREG was used for a governorship election for the first time in the Edo in 2020. It had been used for smaller elections, but the governorship election, and people sat down in their rooms, in their situation rooms, in their bedrooms, and saw their polling unit results. They went to IREG, and that built a lot of confidence in the system. And you can see now that the belief that it had removed rigging, that you cannot change results, because the challenge before was moving results from polling units to collation center. And each time you try to do that, alterations occur. But this time, everybody had access. There was a democratization of the election management system. So there was increased technology, and then you could easily view that portal. Anybody could register, view that portal, and see that, this is my polling results, this is the result of Mr. Beautiful. So it builds confidence. But come 2023, at the time we needed it the most, what happened? Most of us recall, for some strange reason, and another terminology has entered our lexicon. Technical glitch. And I hope if the father will be able to commission, then maybe they will throw more light on what. Unfortunately, in the missed opportunity, INEC has never explained what a technical glitch is, the nature of a technical glitch, and what really happened. What was the judicial attitude? Fortunately, that was interpreted. What is IRA? What is its role? Is it just a mere viewing center, DSTV, Arsenal versus Man U viewing center, where you just go there and watch a match and be entertained? An entertainment center? Or was it a critical part of the architecture for transparency in election management, which many people thought it was? That was one of the serious issues. So with the electoral, again, in interpretation, the Court of Appeal, I think it was this case, said, oh, it's a mere viewing center, leaning on previous determinations by the Supreme Court. But oddly enough, we are in a political elect. It's not enough. It's more than a viewing center, quite honestly. I don't because it wrong. I don't know why I say so. But you cannot elevate it to more than what the law intended it to be. And what the law intended to be, basically, to enhance transparency, it should be a viewing center. But it becomes part of the process later on if the result, the primary result is still the EC8A, the result sheet for the polling unit. That is still the primary the foundation of it. It's still there. Where you cannot get that, the original, you gather from the political parties, you gather from the police, who is given by law, given a copy at the polling unit level. If you cannot get that, then use electronically transmitted results. And I'll try extension. Electronically transmitted results is different from the IRF results. Let's be clear about that. Where all things are not possible, then you can rely on the IRF. I think that's my understanding is the current state of the law. The recent cases seem to have determined that. So that's what IRF was. So why was it that there was no technical glitch for the other elections conducted on the same day? Don't forget, the presidential election was conducted on the same day as the National Assembly, House of Reps, and senatorial elections. Most senatorial elections were conducted in House of Reps without that glitch. Somehow, the glitch only affected the transmission of results from the presidential election. I don't know what happened. We lost the opportunity that neither INEC nor the state took the opportunity to look at that. Then there was also issues, for example, the former Senate President and the current Senate President contested presidential elections. How we conducted presidential elections? What happened? We now saw them, etc. They get winners in the Senate. How did that happen? Should that be allowed? You have contested one position, yet your name appears in other positions as candidates and eventual winners. So people were worried about that. There was also a new term. 2023 is one of a lot of terms. Placeholder. Who's the placeholder? Is there any room for placeholders? And all these things were agitated actually. So they said, well, and it's cut across the parties. APC had a placeholder, PDP had a placeholder, Labour Party had a placeholder. Does the law recognize placeholders? What is the role of placeholders? You will not find technical glitch in the law. You will not find placeholder in the law. But in the lexicon of our electoral process, these have now become entrenched and part of the process. And it worries, it's not so much we in this room, at least intellectuals, lawyers, but what does the average man, the person who comes on, who knows his counselor, who knows his local government chairman, who goes out, queues for 5 hours, in Congress comes on, what does he perceive, what does he think is the electoral justice in this thing? So these are some of the issues that agitated the minds of citizens that led to this bill. And another one came after the elections itself. Oh, we'll get justice in the tribunal. So many of those who won said, go to court. There's nothing wrong with that phrase on the face of it. Because there's a dispute resolution mechanism recognized by law for peaceful, rule of law type of approach towards resolution of disputes. The law recognizes that there will be disputes in any human endeavor. And the electoral process is more contentious than the usual thing. So you will go to court. So let us get a mechanism rather than go to the streets and say, do or die. You will not live here a ghost, you will not live here alive. No. Go to the tribunal of what as the case may be to resolve the dispute. But when one party keeps on saying, go to court, go to court, there's a joke that probably his father goes to court. That they knew you will not get justice in the court. So we settle it there. And then there's a communication after, I think that's 2003 elections, more than 20 years ago, saying justice by court, election by court order, that when all of you, the 23 million people have voted, actually there are more than 90 non-registered voters in the country today. When all of them are voted, the most important votes come in. And it reminds me of the quote attributed to Stalin, who says, those who vote decide nothing. But we know that Constitution says that sovereignty belongs to the people. And this sovereignty is expressed by their chosen representatives. So it's the people who own sovereignty. That's what our Constitution says. But Stalin says that people are joking, that it doesn't matter who casts the vote. What is important are those who count the votes. So that's where the role of the role of the comes in. So it's who counts the vote. But I think in that judiciary, somebody captured it very well and said, no, after all of you have voted, 19 people have voted, it is maybe 5, 6, 7 justices. It is their vote that counts the most. So I think the President Carlo said that after you have voted, then in the 2023 election, the 2007 elections, 7 people decided the votes of 70 million Nigerians. And those are the justices of the Supreme Court. And in one of the cases, I think it was the Buhari case, it was 4-3. And from what we heard, I don't know how far it's true, it was 3-3. The casting vote came from the then CJN, who I don't know at what point it was alleged that it was this way, that way, but anyway, he had the casting vote. So 7 people decided the fate of 7. So the 70 million, it don't matter how much, but that's what the Constitution does. That's giving that power to those 7 my lords. So that is it basically. So this is the background that is how can you contest one position and emerge in a different one. There was a requirement that your register has to be within it for time. And a couple of cases went to court, particularly Labour Party. Peter Obi, you were in PDP. At the close of the time the register was supposed to be submitted to INEC, your name did not appear as a registered member of the Labour Party. Instead, you were in PDP. How can you now contest under Labour Party? That went to court. The way the court decided was that, quite honestly, that is not a requirement of the Constitution. The Constitution says you have to be a member of the party and a follower of the party at the time of the election. So it matters not whether your name was there. This has been attacked and legislated upon. In a few minutes, we'll see how that works. Once in my paper, I discussed about the role of the international instruments. Starting from 1914, it was a declaration of human BBHR, right? ICBC 1966, most importantly, African Charter of Banjul Charter. Those are very important sources of our national law. The right to be represented in one's government, the right to vote. The right to vote, by the way, is not a Chapter 4 right at least. That is correct. It is not a Chapter 4 right. It's not a fundamental human right. But it's recognized in several other sections of the Constitution. And Constitution acknowledges that we people have been assessed the Constitution, and the right to representation is part of the basic rights. So the Electoral Bill was introduced in 2024. It took 2 years. The both houses promised us that by December we should be ready to meet up with international protocols that at least 1 year to the election we should have a settled legal regime. But somehow it was delayed, and we recall the House passed its own bill, issue of transmission and other issues, and then the Senate passed its own bill. So they had to harmonize. And rather than harmonize so that we adopt the House of Reps position that has been discussed so much, I can't go too much on it. They harmonized it to suit the Senate position with improvised, which will come to in a minute. So, how do they say it here? We immediate accuracy. Within the harmonized, with less than 24 hours on it, it was delivered to the President for assent, and he assented to it that less than 24 hours after it was passed. I don't think any other bill has gotten so much. Even, don't forget, this is not an executive bill. You want a bill introduced by the presidency of an executive organization of federation. It's not. So, what time the stakeholders act on? Stakeholders in the input were part of it. Some of the suggestions were taken on board, others were not. When I was in there, invariably when the bill is passed, it comes to INEC, and as director legal, we had to use the full com to go clause by clause to look at the bill and see that it will satisfy concerns and everything. It also goes to the Attorney General, who now looks at it. Well, in 2004, we presented exactly 20 years before we presented the bill that became the 2006 Act. that bill was drafted by INEC itself, taking into consideration stakeholders' concerns, taking into consideration architectural management and regulatory of the system, who drafted the bill. When it got there, there was a problem. The National Assembly refused to accept it. I said, what is this? INEC has no right to present a bill for the National Assembly. Is it a private member's bill? Is it an executive bill that maybe you want to send to the trial? No, I said no. INEC is recognized as an independent, operationally independent constitution. I am not subject to the Attorney General of the Federation, so I will not pass this way. We send a copy to the Attorney General. If he has comments, just like every other stakeholder, when there's public hearing, you go and make your own submissions to the National Assembly, and then that will be something they decide. They are the lawmakers. But I will not be subjected, even though we're an executive, we're a federal, we're a national body, not a federal body. Independent national, not independent federal electoral control. The difference between federal and national. National belongs to everybody, whereas federal belongs to the federation. Just like the state has certain things, federal has certain things, local government has certain things, but we are a national body owned by Nigeria, corporate Nigeria. So we will not subject to that. There was a long debate, and thank God for Professor Osumbo, who was chairman of the trial committee, and said he adopted it became on this committee or private members bill, and that's how it became law. Now, so the question arises, did this bill or the act, when it came into being, they missed the deadline in December, they now finally passed it February 18th of 2026. Are there fundamental differences between this bill and the act, as it was now, and the 2022 act? Did the act address all the issues raised in that previous act? Does it correct our fears? Are they our fears? Does it correct the impressions? Does it do what it set out to do? So I've outlined some of these things that set out to achieve these goals and these parameters, and can it deliver better elections in 2017 and subsequently? And don't forget, it's a repeal bill. It repeals the old act. So the hope is that it's something new, something different. But is it new? Is it different? And if it's not, you know what they say. What is the definition of that word? Where you say you keep repeating the same thing over and over again in the same way and you expect different results. Madness. So, does it fall into that, or is it a radically different thing that will deliver better elections? So let's come to the bill itself, the act itself. What's new in this act? There are all sorts of things. Time not permit me to go through everything, but basically it's resembles almost identical between the 2022 act in terms of structure. There are 9 chapters, the headings and the side notes are basically the same, but it has 155 sections. The old law had 153, this new one has 155. Does it define substance? Basically, the highlights is the good, there's the bad, there's the ugly. People who want the good, when the Senate President, leader of the Senate, Senator Okoye, was introducing this bill, he praised the bill to high level. It's so good, we're establishing a fund, good timelines, we increase penalties, increase technology. He said all those things. I wish I could read the whole thing, but please Google it and find out. There's the ILTF, the official site for the National Assembly in terms of research and things like that. It had a statement in full. But it talked about reduced timelines for several activities. Is this a good thing or a bad thing? Let me take one of them. For example, Section 3 talks about funds for energy. The old law said that funds for the Commission, according to the Executive Commission, the first version was released 360 days, 1 year before elections, but we appropriated and released to it. The National Assembly, in its wisdom as lawmakers, reduced this to half of that time, to 180. How do you strengthen the Commission? By reducing the time it should get. And when you reduce such time, it limits the time for planning. It limits the operational efficiency and the impact on the logistics. And don't forget, the Procurement Act is also applicable to INEC. So not only must you have funds appropriated, but you must also have the funds in your account released to you. There's one thing, as those in public sector tell you, there's one thing to appropriate funds, there's another thing to get those funds released to you. And you go to budget's website, you see how much of last year's budget was appropriated and how much was released. In some cases, 0. In some cases, 10%. Hardly ever you get 100%. So the contract says, before you award any contract, and INEC must depend on contract from critical about paying back to logistics for every tenant. You must have these funds in your account. Can it have this fund? Viva is not, and most technology providers are not put off shelf as in the supermarket. You must place orders for these things. and this thing takes time. And most of this time, the software may be designed here, but it will go to China or some foreign lands to get it printed as well manufactured. Now, this timeline, I'm afraid, is a bit of a constraining factor. In section 92, they talked about increased expenditure. So for president, for example, I think it was increase from 5 billion to 10 billion naira. The increased expenditure, so you know how the naira has been this past 4 years ago, but also other clients approach it differently. They base the expenditure usually on the number of registered voters and per head as a smaller for it. But in our approach, we just fix an upper limit, and I've been in our world that way for quite a while. So governments, for example, are not allowed to spend up to 3 billion naira. And by the way, this talks expenditure by candidates. It doesn't talk about political parties. That's a different issue and a different section, which has to be fixed by INEC in consultation with political parties. That's the same as between the two acts, so there's not much difference. Now, registration was touched upon by the new act. Section 10 limited the number of instruments we use and quality type of instruments. So whereas the old section 10 talked about ID card, passports and things like that, when we quickly let's see the difference. So section 10 talks about all the things that you need to do in terms of things you can use your birth certificate, national passport, identity card or driver's license, or any other document that will prove identity, age and nationality of the applicant. It's not unfair, You can use any of those things to prove. But what did the new act say in section 10? Now, and these sections remain basically the same thing. But they are now limited the things. I don't know whether you can spot the difference. The technical glitch here. When I have microphone. Yeah, thank you. So now transition resume. What does section 10 of the new act say? So each applicant for registration and control correction system shall appear present at the registration with any of the following documents: Nigerian birth certificate. So if you are born in the UK, and many Nigerians are born abroad, and many Nigerians outside the country also want to register and involved in the process. So the other one just said birth certificate. This is Nigerian. This one has qualified as a Nigerian person. Then the old one said, for example, national passport, identity card, or driver's license. But the new one says Nigerian passport. So if you have a UK passport and you have a nationality, I'm sorry if your Nigerian passport has expired, I'm not sure that will suffice. But it says Nigerian passport. So issues of identity card, driver's license, it shows your age and it says those ones are out. Then it says national identification number. Don't forget, it says you should come with this document. I said good provide the see how popular this is. It says document. Is the national identification number a document? Even if you bring your card, don't say national identity card. It says national identity number. It's your number that we'll use because that's if you take a literal interpretation of that, that's what it says. So these are some of the things. I don't know why that was done. I'm not aware of anybody pushing for this, but that's exactly what happened. Then in section 18, you have the damage. If you have lost a damaged PVC, you can get a new one. But the good introduction about it talks about downloadable PVC that people read. Whenever a voter's card is lost, destroyed, defaced, torn, or otherwise damaged, the owner of such card shall not less than 90 days before polling day apply in person to the electoral officer, other officer, or apply to the direct, stating the circumstances of loss, destruction, and defacement. But there's a provided that nothing in this section shall prevent the owner of such card from printing a downloadable copy. Let me show you part of the ugliness of this. Let's refer to section 21. Section 21. The proprietary rights in any voter's card issued to any voter shall vest in the commission. So the owner of the card is the commission. But here we are stating that the owner of the card can print a downloadable PVC. Is it when it's damaged that can print a downloadable PVC or not? These are some of the little issues. And it's just ugly. When you build on the foundation without going, taking pains to go through everything, it gives you cross-references is a bit of a problem. So that is it. Then let us see another thing. Section 77 deals with submission of electronic registers of members. And this is likely to be a major issue when we come to elections. Why? Because the previous act said that you just send a register to the commission before election. But now this has been expanded. It It says in electronic and manual format before your primaries, and only this register shall be used for primaries. But then in this cycle of primaries, I don't know. It's for us to say. I think the NBA did not send observers. That's a lot of meeting. Maybe did they comply with this? So what happens when you do that? Not only must they send the register, they must add the name, the identical number. They seem to this national people like this name so much. You must add that to all members of your political party. Then, interesting part of it. Only people whose names appear on the register of members are entitled to vote at the primary or be voted for. So, some argue this seems to add another dimension. Issues of qualification and disqualification. Qualification and disqualification says you must belong to a political party and sponsor to that party. And not only must you belong to that party, you must submit your name. Your name must appear in the register of voters at least 21 days before the primaries. Your name must be there. Is that not adding to the qualifying requirements of the Constitution to say to vote and be voted for, you must be part of that thing? And you know what? And the design is there. What happens when my name does not appear on the register of voters? Technically, if you are to attempt this one, then sorry, too bad. But there's no timing for joining political parties. Can I not join on the eve of the primary and be voted for? What is Section 40? My right of free association, does it not breach it? Am I not allowed to join a political at any time and have equal privileges, non-discrimination as other members, as long as I join before the primaries and before the election and the member as possible, and I meet the deadline under Section 29 of submission of list of candidates. So queries arise from there. And don't forget Section 5 says no other register shall be used. It's only that one sent to INEC at the time of giving them notice of your primaries that can be used. So that's it. Then two, we talked about the issue of accountable to parties. Non-submission under Section 77 disqualifies parties from sponsoring any candidates at the election. We don't comply with it. That's that. I just picked some things my special. Let's go to Section 65 of the Electoral Act. This was a great innovation in the 2022 Act. And Section 65 of the 2022 Act is very, very straightforward and clear. And basically deals with the issue of review of results. It arose from IMO. In IMO, two senatorial districts had problems. One, somebody pointed a gun at the head of the returning officer and said, declare me the winner of the election. And to be fair to that man, very courageous man said, I'm going to declare this one because they have a gun to my head. He said so publicly, take some pictures of it. I'm going to make this declaration. It's not my free will, but because there's a gun to my head, I have no other choice. As I once said, you don't argue the man with the gun, loaded gun. So he made a declaration. INEC refused to give a certificate to that one. The old law as it was, INEC was not good start. So he went to court, and the court complained, said, sorry, the statute says that once the declaration has been made, only a tribunal can question that. The second one, the returning officer collected, I think, 16 out of 18, certain number of we had completed coalition. And so those outstanding work were disrupted, they were preventing people from coming to the coalition center. So what did he do? So the official he made a declaration. Went ahead, made a declaration. But no, sorry, not make it, he collected. Rather than declare in the constituency, he ran to Abuja and came, and the first person he gave was the coalition at the International Conference Center, was a coalition for the presidential. They came to meet me. I said, no, sorry, we cannot accept you here. The declarations for Central are not made here. Go back to Owerri to do it. He had to debate, so I had to call somebody else to come. Do you know this man? I said, yes, he knows him. He's a professor. He didn't make a declaration. So anyway, long and short, we sent him back. Again, we refused to give him a certificate. He went to court. Court said, the law had no right to do. So because of that, inequity submission as a justified, the decision, 2022 Act, the decision of a returning officer shall be final on any question, blah, 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 provided, and that's the interest part, provided that the Commission shall have the power within 7 days to review the declaration and return where the Commission determines that said declaration and return was not made voluntary, the man was on his head, or was made contrary to the provisions of the law, regulations, and guidelines and manuals for the election. So So not just contrary to law, regulation, guidelines for the election. What the National Assembly do, I'm surprised, I think it was one of the memo submitted by the Commission. I was very disappointed that they decided to do that. But let me read what they now said. Don't forget what I said there. In elections, the office of President of Governor, whether or not contested, so that's the third. So any election, the results shall be ascertained by that. And okay, sorry. It also have power to within 7 days review the declaration and return when it receives report from its officials. In other words, the report was come from its officials. Under the old law, no such restriction was placed on the Commission. And it is satisfied that the declaration or return may have been made under duress, no problem with that. Or it will be made knowingly and willfully under the procedures of guidelines section 2 of the Act. So you have added ministerial elements of knowingly and willfully. That was not there before. What is contrary to the guidelines, the manuals, the Electoral Act? Here it is limited to a particular section of the Act, sections 2, 4, and 8, and also the number of people who have the question. What happens when the officials are the people who are clamoring against? That the people who were the ones complicit, like in the second Imo scenario. This man was the man who came, did not make the declaration, went to Abuja. What happens when we have friends in Abuja? That's why the way overbearing nature of certain politicians now over the Commission. And the Commission doesn't do this or whatever. So because of that, how did this improve the law we want to pass? So these are some of the issues. Then I want to section 137, but before then, and tying to that, then come to proof and judicial attitude to proof. Now, I said here that the courts had, even before now, watered down the effect of some of these provisions of the old law. An example being the presentation of forged certificates to women, which hitherto was a strong ground. Okay, strong ground for this. Now, the issue is this. Part of this qualifying factor is that you present a forged certificate to women. Easy, that's one of the easiest things to do. But now, first of all, judicial judgment was that down. That's not enough. That first of all, you must go to court. You must get that declaration made that is not convicted. Not even just declaration, you must get a conviction that this man has been convicted. And then, the court will appeal, that stays everything. They have been convicted, you present a false certificate, and then use that to come to bring it before the tribunal. Otherwise, it's a pre-election issue. That will be watered down. But the law has not that matters now. The law now says grounds for presenting opposition. Now says the grounds for presenting opposition is off. So issues of disqualification and qualification, and it's so important. There must be a distinction between qualification and disqualification because it's the Constitution. Regards them as so important. We need two different sections of the Constitution, not even blend together, not a proviso, but one. First of all, you must be qualified. When you show you are qualified, they will go, are you disqualified? So we'll not come to disqualification. But are they self-executed? If a person comes and says, I'm a Chinese man, I'm under the age of 25, I want to contest presidency, and nobody is objection, under the old section 295, anybody, once the aim of display, and the purpose of display is that people should be able to, I know this man now, this man did not go to this school, like many people both in this state and nationally who went to schools that did not exist when they claimed they went to those schools. Schools don't exist there. So I should going to challenge you. But now they're not self-executing. That's a problem. How then do you ventilate this? Because under section 295 now, only aspirants who took part in the election, because of the statute that amended, can query that have no to query it. Only people do. So there's a very narrow reason you from another party or other members cannot query unless you took part in the election. My time is limited, so let me just quickly run through this. Section 137 of the old Act has been completely deleted. What does Section 137 say? It says when the document shows malpractice or an irregularity on the face of it, you need not call oral evidence. And maybe in conclusions, I'm sure someone like Ken Bosia, SAN, this is one of the latest ones that people have pronounced upon. Again, no commercial collection. That's what it made against it. And they said, no, it's not sufficient to just say, oh, come on, bring But I had a result sheets and I saw those of 200 people. And meet only 150 people were there. That is useless in the face of it all. And should be enough. He said, no, you cannot do that. You must look up somebody who was that polling unit, the polling agent, or someone who was there to approve this thing. So the ones are going on evenly distributed towards the petitioner through any state. But who's one alleging? Because there's presumption that it is correct and it's okay. But Section 137, now, we had problems with Section 137. Now the new act has completely removed Section 137. It's no longer there. So putting a heavier burden on petitioners to prove, even when they are documented, they say, no, you are documents. Document people must call somebody to speak to each and every one of the documents. You must call polling unit agents from every polling unit. The president 176,000 plus polling unit. You must call where infractions took place. All of those places. So the burden is on you. You cannot have electoral justice so you have that. So if you want the electoral, you must look at that bonus and burden and change things. In a certain case, you had three different results in many units. You had the EC, all certified. You had the EC8A, the primary result, certified by INEC. You had the EC8A given to the political parties, the agents, and the police, certified by INEC. Then you had the INEC one, certified by INEC. Three, in many instances were different. Yet you say, I have the burden to come and show that it was legal, and which one is genuine, which one is not genuine. Three certified copies. This is the kind of burden. And you have to have a break from what German I have here. This is the kind of burden. The beavers, you are bringing beavers. Not only must you bring beavers to Tribunal, you must demonstrate, open each beaver's machine. There was 6,000 more, 5,000 for each thing. If you have problems with 5,000, you must bring beavers to every tribunal and open the beavers, demonstrate it. In the meantime, it's not under your control, it's under your control. It's under the control of INEC. And I cannot operate it, you cannot operate it. Only INEC officials can operate it. And what the Supreme Court saying there will be an INEC and a INEC. That it's not sufficient that if you want to call the Supreme witness, not witness Supreme Court tribunal, but you call the Supreme Court tribunal will issue and then subpoena, then you have to front load the testimony of this person, front load those witness statements on oath. I thought the law said you cannot do the command impossible. But my adversary, I justify the results. I want to bring the person, get his witness statement on oath, and bring it to you. No, I don't know. So, in conclusion, there's so many others, but two things that we have great concern to us. Section 83 and Section 138. Now, if a lawyer brings an intra-party matter before the court of tribunal, he will be fined a minimum of 10 million naira for bringing an intra-party matter. The law doesn't define intra-party, but will be fined 10 million naira. NBA is silent. If you go outside the grounds, you say this might not qualify by the Constitution, you bring a petition before the court, he will be fined minimum 5 million naira. We know that especially lawyers have abused this thing and are bringing all sorts of frivolous things to court, but that is what the law says, you must be fined. What does that have to do? What does that have to discipline? I thought we had a section 10 of legal practice disciplinary but that's a different thing. Are costs supposed to be compensatory or are costs punitive? Are you punishing? Are you costs against people in a punitive way or is it supposed to be? Can court make others? It's a lawyer party. Can court make others against non-parties? But already the court is using this discretion and find two very senior lawyers 20 million to destroy this kind of thing. Is that not sufficient? Must we legislate over a thing like that? Is that even constitutional? Does it not affect our police who advise our clients and bring cases before the court? So basically, gentlemen, the 20th article, the basic principles of previous acts, they include time for evidence, bonus and duty of burden of proofs on the petitioner, all allegations of crime will be proved beyond reasonable doubt, overvoting can be proved by plea and pleading and telling, the register of voters, the previous machine, and the PU results is 8A. Primary evidence will be called regarding infractions in every polling unit. The documenting itself by not to any infraction, even if it's obvious on its face. So, in conclusion, I thank you all so much for listening to me.
That was a very silent round of applause. I would prefer a supersonic round of applause. A heavy round of applause. Thank you, gentlemen. The reason for this is that when you have a seasoned and redoubtable advocate to review a new act just passed on 18th of February this year of 155 sections, comparing it with the Bold Act of 153 sections. Initially when we started, he said, we are doing the same thing, the same old ways. He said it is pure madness. So he traced the old electoral act. The first one was the first issue he picked was the IRF, based on technicalities but full of defects, though it builds confidence. Then he said that 2023 was full of technical issues. Then he questioned the meaning of placeholders in the new act. Then the phrase "go to court" to infuse confidence on the voters rather than to riot. We all remember where it's in the West. So then he now questioned who could vote, who counts the votes, whether the 7 justices of Supreme Court or the 70 million, the over 200 million or 70 million voters. Then the defect in the act, does it count, does it correct our fears? Can it deliver, or is it different? He just said that we are doing the same thing the same way. That it resembles 2023 or 155 section and the 153 section. It talks about timeline, which limits time for planning. Section 96 on the fixed limits, registration under section 10 and 12, section 10, critical of section 10, what if you were born outside the country, Nigerian passport. The NIN number is different. Then section 21, proprietary right for voters card owners. 77, sending registration card either electronically or physically, limiting the time frame when you can join a political party. Then he now said, we cannot have electoral justice based on everybody or proof placed in this recent act. These are things, questions that I know will agitate your mind. Without wasting your time, I just want to say the God rolling that he has really raised some vital issues, which I won't have to talk, but I would like to listen to questions from the audience. I'll give the next participant 15 minutes. Because we gave the last participant 30 minutes, we spent 15 minutes. So I will give an extension of time to the next speaker. Instead of 10 minutes, 5 more minutes, making 15. Thank you.
My lords, the worshipful magistrates present, the respected senior advocates present, elders of the bar, distinguished colleagues, fellow discussants, the respected Mr. Oluwole Uzi. I permit to stand on the existing protocol, even though I have stated the protocol already. Mr. Uzi has done justice to the topic, and I wonder what else there is for me to say. The good thing about speaking after someone who is very knowledgeable in an area is that you will just hide under his shadow, and that's exactly what I'm going to do. But beyond that, when I was told this morning that I was going to speak on this topic, one important issue agitated my mind. And that issue is what Mr. Oluwole Uzi landed on. And the question I've been asking myself is it possible in Nigeria today to question effectively a process of an election that has taken place? I will leave the answer to you. But if you listen very carefully to the last comments Mr. Uzi made, the answer is very obvious. And if we call this a democratic process, it should be a process that can be interrogated. If a process is democratic and cannot be interrogated, I beg to say that it is not a democratic process. It is at best a tyranny. So if I have to wake up in the morning on the date of an election and go to the polling unit to cast my ballot. And I get to that polling unit, and I see that, and I'm told that 200 people were registered to vote in that polling unit. And when the elections, the results were declared, 1,500 people voted. And I'm beginning to ask myself, how did this miracle take place? Now, those results are sent through IREF, and it's in the system, and then the person who lost the election decides to contest the election through an election petition. He gets to the tribunal, and then he's told, getting to the tribunal, he even faces a big challenge, because getting those documents to demonstrate that he won the election is an issue. And then the institution, the person, the entity that conducted the election is a party to the case. That party is not called upon to show by credible evidence that it conducted a proper election. In fact, on some occasions, INEC may even decide not to call evidence. They may even decide to just sit aloof and watch the parties bicker. And then at the end of the day, judgment is delivered. What touches my heart the most is the fact that I present a Form ECA that shows that 200 people were registered to vote, and at the end of the day, 1,500 persons voted. And I have such a document that shows alterations, that shows acts of criminality, that shows acts that should send someone to jail. And the system tells me that even though I can see that this document is faulty, I still have to prove beyond every scintilla of doubt that there were irregularities at the polling unit. And so what I'm expected to do, if I'm challenging an election in Igbobaoha, for example, where you have about 600 and something wards or polling units, I have to call a witness from each of those polling units to come to court. Mr. Mother is laughing. We learn, and by the way, there's a lot I would like to tell you, maybe after I've finished my presentation. And we're expected to present over 600 witnesses to come and show that they are registered voters, they participated in the election, they voted in the election. In fact, one very interesting one is the fact that during the course of the election, a fight broke out, right? And the fight was recorded, right? And then the tendering evidence had to show that there was a fracas and the election did not take place. I am told to show at what time did you record the video, right? I'm told to demonstrate that this video is linked to the very spot where the election took place. It now appears to me, like the Bible would say, that it is easier for a camel to go through the eye of a needle than for a rich man to enter into the kingdom of God. It's akin to the same thing, the same burden of proof that is imposed on the petitioner to show that the election he lost, that there were irregularities. And then the party who is supposed to show that it conducted a free, fair, and credible election is not asked to say anything. I think that is most unfair. And I wonder, is this a democratic process? Can anybody who has lost an election go to the tribunal and be sure that an election will be overturned based on these grounds of presenting an election petition, my answer with the greatest respect is no. And that is why what the electoral dispensation has simply done is to infuse and impose on the politicians to ensure that in every election you participate in, just make sure you win. And then afterwards, the popular phrase, go to court. Because when you get to court, it will be difficult because the case laws are there. And for the judges, they have to follow the law. You have to show that in each polling unit, there were irregularities. And if you can't do that, there's nothing the judge can do. The new dispensation we have now talks about the fact that the qualification of the aspirant is no longer an issue. They've taken it out. So whether you are qualified or not, you cannot raise that issue in the tribunal. You have it has now automatically become a pre-election matter. And I ask myself the question, at that stage, am I able to know the qualification of the person who is conducting the election for me to be able to challenge that qualification? At what point will I know if he is qualified? It therefore means that you simply put a bowl of food on a cupboard and then you ask a cripple to take it. He cannot take it. I'd like to make a last point. Whatever form of alterations, amendments we make to our electoral process or our electoral laws, what is most important to the man in the streets is that a free, fair, and credible election took place. Whether we like it or not, we have to deploy technology in the conduct of our election. That is the only way out. Thank you.
Thank you very much. The second speaker has emphasized what the first speaker has said. He started by asking whether the electoral process and the new electoral law we have now, whether it's a process that can be democratic. He emphatically stated it is tyrannical. He based his conclusion on the everybody of proof placed on the petitioner. I leave the rest to members of the floor who ask questions. I now ask the next speaker to take the floor. The next speaker, listen directly beside me here. Please take the floor.
Thank you very much, President. Permit me, sir, to stand on the existing protocols. I am Akon Adoloyi Osayomabo. Akon Adoloyi Osayomabo is my name. Thank you, sir. I think the place I will start from, in reforms, you are tracing a new route or creating a new route, you trace the older ones. When in 1998, this republic started, or this dispensation started, there was a guideline stating that to form a political party, you must win specific number of seats in specific areas. And at the end of it, the political parties that were registered had seats won from the local government areas. But presently, we have, I think this morning I saw we have 21 political parties presenting presidential candidates. And several of them do not have local government area that they have a base. And if that one is out of it because of the executive tyranny, then we have lost out from our foundation. 2, the areas of election, petition, and the lawyers, their willingness to stand out and be able to determine the way forward for our nation. My Oga of blessed memory told me that he was in a court and a senior lawyer, Papa Dog, told the judge that your judgment is in upper market, and those that have won, they have a white chalk to celebrate already. And the judge looked at him and said, "What are you saying?" He said, "I am saying to you that your judgment is in upper market. The people who won, they have the white chalk already to win, to celebrate." After about 5 minutes of wrangling, he said, Justice Uwaifo went to the judge and said, "Let's go into the chambers." Then Justice Uwaifo was the Oga of my late boss. And when they got there, he was bold enough to tell his lordship, "Bring out the judgment you have written. If it's different from what I'm saying now, put me into jail." The judge looked at him straight in the face and he said, "I will send this matter back to his lordship, the chief judge, for reassignment." That confirmed that what Papa Dog said was true. You know, in the last election matter we had, it was a Kemes matter. Ken Musa is here, he led me in that matter. They came to the tribunal to tell us, the people who were, he said, "We have won. See the area of our winning." I went back to Oga and said, he said, "No, we will write our brief." We wrote our brief defending that area of the action. Because they said the man who signed, Odibeli signed 4. Mawan was Odibeli signed 4. And on that basis, and that was what they told them in hiding and in secret. And they brought it to the open that that is the area we will stand on to nullify your petition. Because the Court of Appeal was the final part, we will not go beyond it. But the moment after the Court of Appeal decision, the Supreme Court came back to say, what we said earlier, before or off, is the same thing. So long the lawyer who signed had a name and was enrolled at the bar, that petition was a complete petition. Meanwhile, at the Court of Appeal, it had been nullified. And we came back home weeping over nothing. So the lawyers should be outstanding and be bold, like Papa Dog was bold. But because of the tyrannical nature of our executive now, running and giving dictations to our judges, giving dictation to our judges of what to do and how to do it, then the judges cannot have the boldness to say otherwise. Look at the other day when they were defecting at the House of Assembly. Suits were filed against the defecting parties. But when the judgment came to say, oh, that defecting party, the publication in the newspaper came after you filed the action. It means you filed the action after or before the man defected. But the publication in the newspaper cannot be the exact day the defection took place. And if that interpretation is given, therefore we are missing. So the judges, if they are bold, like I appreciate the judges we have in Edo State, the number of states they have sent them to, they come back with outstanding results and judgments. The first election petition I took part in was a local government election. The judges were sent from somewhere to come and they were quarreling over how to do the judgment. Two of them came out to deliver judgment inside there. You know that place where we have a canteen now? That was where their hall was. While they were quarreling what the judgment would be, two people came out from the chamber to deliver judgment, while the others were still quarreling. I was there, my God was leading me, and I sat to witness it. So this boldness, this desire, this issue of election petition that is now trying to come forth to the fore must be attacked with seriousness, so that at the end of the day, the executive tyranny will be directed or redirected. Because if we, who are the lawyers and the judges, who like Sazer Ruzi said just now, are the few numbers, only 7 will come up to say that the entire thing, 270 million decided, where you see 3 of you are this way, 3 of you are this way. Let me give a casting vote. Who gave you the casting vote to give at this point? That these are the areas of concern in our electoral acts. Let's come into the primaries that we are doing now. Primary election, we say it is the responsibility of the parties. And if it is the responsibility of the parties, there must be guidelines from the political party. Why will the presidency sit somewhere to determine how Party A will elect members of his own, his party officials, and also those who contest against him? If I'm to determine those that will contest against me, I see those who are stronger than me, and I will remove them ahead of time. And that is what they are doing even in the primaries today. So the primary is expected to be the responsibility of the political parties and not interference from anybody else. But interference from the side by reason of electoral acts, electoral guidelines, electoral determinations. You know, the guidelines now tell you how you do your primaries. But in the other dispensation, the primary is done by the parties, by the INEC president only observes. INEC has no say, has no business with what the party is determining. It's only present to see that yes, actually, on the day fixed, they did their primaries. But today, by reason of the INEC guidelines, the INEC determine when, how, and who to contest in your primaries. That is not supposed to be the democratic formula for us to follow. In 1998, when we started, the parties will sit down, they will agree and disagree who the party present the list to INEC. But now the INEC comes to take the list from the party primaries and say we are going to read it in Abuja. Is that democratic? Are you giving the people the opportunity to choose who to represent them? These are selections by INEC. And the guidelines that INEC is providing for our election must not be the guideline that should determine what the primary should look like. And the INEC guidelines should also not be the guideline that should structure our own political standing. Because all these things are supposed to be determined by the people by themselves. And it should be, it was announced now, or when my own said, I'm a member of PDP. Yes, from the word go, I've been in PDP. So, because I know the runnings of the PDP, I should be able to follow the path that PDP should stand for. ANPP has its own direction. APC has its own, because when it started, I think there were 5 parties that were registered. 5 in 1998, after the first local government elections. So the local government elections that determined 3 parties. Yes, PDP, ANPP, LPP, and AP. So those were the only parties because they won local government seats. And they formed their party by themselves and they were able to determine the selection of their party membership. And the other area in this party primaries that is making our political party fail and struggle for positions is lack of ideology. The NP people then, that was the Obafemi Awolowo people, they have their own ideology following the path of Obafemi Awolowo and his activities. The APP were those who have their own specific direction, and PDP also had their own direction. But this time now, the ideology was now collapsed into financial or something infrastructure. But this is so much infrastructure. So this idea of infrastructure that they now struggle for is the one that have corrupted our party or democratic dispensation that we are in. Everybody is looking for what he will eat and where he will go eat. They no longer, like I read through something, in Nigeria, we have very few patriotic ones. All others are idiots. Because they allow ethnic sentiment, they allow religious sentiment, they allow all other activities to cloud their patriotism. They no longer have Nigeria and the rule or ruling Nigeria as a focus. All they need, how and what is my religion saying? And because this person is from my ethnic group, I must support him, even when he's failing. If this one is from my religious group, I must support him, no matter what happens. But when we allow patriotism to rule and dictate the way we follow, we should be able to state clearly, President A, you are not doing well. Governor C, you are not doing well. Because we need to understand what we and what our children do. We are talking about what we build today determines our future. If we fail today, our future is already beclouded. And that is where we are at the moment. Politically, democratically, we are not in the focus to see us through to giving unto our children. A Nigerian state we received in 1960. The Nigerian state we received in 1960 passed to 1963. We are not able to give back to our children that kind of state and situation. And because of that, we need to retrace our steps. All this idea of guidelines, INEC guidelines, I won't say their guidelines are fraudulent, but the guidelines that INEC is giving cannot be implemented because the electoral act, they will come to tell you that is INEC rule. It has no place in the electoral act and has no function in the constitution. And by the time the political parties follows those guidelines to say, we will get justice, and they will tell you, no, the guidelines have no basis in our own electoral act, so it is jettisoned. So the guidelines, like I said, I won't call it a fraudulent process, but they should remove such guidelines and allow the parties run and do their businesses the way they feel. 2, the present electoral act which we have, if you look at the electoral act that they have given us now and the electoral act we had in 2022, you will see how they have corrupted the whole process to favor some groups. In 1998, I think the Meji something was in the House of Reps and was elected speaker. And they said, oh, your certificate is from Toronto. You cannot be a member of the House of Assembly. He silently left. But now, that to question the electoral act now have become an act of the past. Therefore, making everybody who struggles to go to school an end position to be of no consequence. That you cannot now question the result that somebody is presenting or see it. So, how do we now have a professor to rule us as a president? The professor will not have so much money, but the president who is coming without a certificate will have much money that he can overrun the professor. But if we allow intelligence and understanding and knowledge to rule us, because every board must stop at the tip of the head. And if the board coming to the head is more knowledgeable than the head, it is the head we see it, will not even, sometimes we will pass it and will not understand what the instrument is saying. So what I'm saying in effect is that clause or that section of the act that was removed is questionable. 2, the part that they have brought in, that the lawyer filing a process should be sanctioned. I think lawyers, particularly our senior lawyers, my senior SAN, Ken Bozia, they can on our behalf take up such sessions, bring it before the court and ask that it be expunged from the electoral act. Because if you, before you start a process, you have already told them, don't question this part of it. Don't question this. And if you question this, you will be sanctioned. Then everybody will be afraid of people following it. So we can take steps to question and get those areas washed from our constitution, from the electoral act. Because like it was said yesterday, the intimidating part of the law that is going on in the Supreme Court now, that when you file an application, your own is taken care of. In all, I say thank you very much.
The third speaker, he himself is a politician. He said so. He said he's a member of PDP and is still a member. But he attacked the subject from three dimensions. He started on a different note based on confidence reposed in the judiciary. Whether that confidence is well placed or misplaced. Are we buying judgment or is it for sale? You raised that question. He challenged the bar to challenge the court's confidence. And this is serious cause for concern. He raised that issue and leave it to members of the audience. Then the second leg has to do with the political parties themselves. He said, who conducts their primaries for them? That as at today, INEC gives guidelines or timelines for party primaries. Another very serious cause of concern. That the INEC takes the list from the parties and announces in Abuja. Then thirdly, he challenged the political parties themselves. Whether they are made up of patriotic or non-patriotic members based on their ethnicity, kinsmanship, religious background. He concluded that today political parties are made up of fools governed by stomach infrastructures. He calls for a new reorientation. Before the last speaker takes the floor, I think it's the last speaker today. Is the INEC President Electoral Commissioner. I would like you to take the floor and deliver your opinion. You will speak up, sir.
Thank you very much. Thank you very much, Lord Justice Kadri. I want to start by saying a few things and correcting some of the wrong notions expressed by the last speaker. First, I want to say that election is a national project. It does not belong to INEC. It belongs to everyone who us as Nigerians. The people that are involved in the conduct of elections are Nigerians. And lots of stakeholders are involved in this. INEC is only the body that is at the center of the conduct of the election. Let me correct a few things said by the last speaker. INEC is not involved in the primaries of political parties. We are not directly involved. We do not collect the list from them, and we are not the ones that announce it. It is the internal activities of the political parties. And we've seen the primaries that have been conducted by the political parties. The jury is out on that, how that was conducted, and if it was democratic enough. And even after the primaries have been conducted, we are still waiting to hear who won and who did not win. And this is a part in an election conducted by political parties for a very limited number of people. 1 week after, we are still asking to know who won the primaries. Let me also correct the other thing he said. He made reference of someone who was elected into the House of Representatives and wasn't qualified to be in the House of Representatives. I think he mixed it up. It wasn't Dimeji Bankole, the political parties. After that, INEC had to now review the portion we talked about winning elections. We now had to review, and on the basis of which political party had won a seat or not in all the elections, we now reviewed, and the number of political political parties dropped significantly. One of the key changes in the new Electoral Act is the fact that, as a person, I've always spoken against the attempt to micromanage political parties. I believe that political parties should be given the free hands to decide their own rules, how they want to select their candidates for the election. About 12 years ago, I wrote an article where I criticized what was becoming known as consensus candidates in political parties, where I said that political parties were becoming very undemocratic by adopting what was called the consensus candidature, which meant that in practice, it is the most influential member of the political party or a cabal in the political party that would sit down and determine who the candidates of the parties in an election is. Now, unfortunately, in the previous Electoral Act, they actually created 3 means of selection of candidates by direct primaries, by indirect primaries, and what they call consensus. I remember criticizing the consensus idea. And then suddenly, with the new Electoral Act, they removed the indirect primaries. And we are left with direct primaries and consensus. And we have seen the effect of that across all the political parties. What is now playing out is that we have a situation where political parties have become very undemocratic, even within. And these are the people who will now come to aspire for higher positions. I recently had to, in an interaction with a friend who is a member of one of the political parties, we were asking him that, okay, party primaries have ended. Who are the candidates, who won the primaries in your parties in certain areas, like in a particular state? And he said the leadership of the party at the national level will announce all the candidates. And I said, this is a top-down, that this top-down announcement is equivalent of dictatorial structure of micromanaging political parties. I now ask, imagine if INEC conducts election for House of Assembly, and election is concluded, and INEC says the final result will be announced by the headquarters in Abuja. What will be the reaction of members of the public, including our elected colleagues? Now, this is happening in the political parties, and I do not seem to have heard a lot of people complain about this. This is because we seem to have agreed that our political parties are operated and run by people who are not Democrats as individuals. Even after the shenanigans that they call political party primaries have been concluded, it's been difficult to announce results or announce the list of the winners. But this is still being subjected to administrative doctrine by the political party's leadership. This is the same way the generality of the Nigerian public, this seems to have been accepted by us because I've not seen a lot of complaints about this. And this seems to be the same way the generality of the Nigerian public has accepted that local government elections should remain a sham. These are the building blocks of democracy, and we are overlooking them. But when it comes to general elections conducted by INEC, even with the detailed processes that are meant to guarantee transparency, everyone will grow fans. So if anything goes wrong in the main election conducted by INEC, we hear everybody complain about it. But we fail to build democracy from the grassroots when we allow the sham that goes on in the name of local government elections to go on, or the sham that goes on within the political parties to go on. Somebody talked about the fact that elections in Nigeria gradually are now being determined by about 7 persons who sit as judiciary. And I recall that as far back as 2026, I had cause to write about this, where I referred to the judiciary as the new electoral college in Nigeria. You know, in the US, after the election, it's the electoral college that now eventually elects the people. And that's beginning to seem like what we have here. Every election, even people who lost the election fair and square, we still want to challenge it, hoping that by some technicality they can win at some point. I was surprised recently when I listened to an interview granted by revered Nigerian Chief Olufalaye, who contested the 1999 election against Chief Olusegun Obasanjo and lost. And I was surprised that as of 2026, Chief Olufalaye still says he believes he won that election. And it was autonomous. I was shocked that if at this stage somebody like that could still hold on to that, then it means that every election, anybody who loses will keep saying he won. And I also remember that the immediate past president of the country, the late Buhari, when he became president, I was surprised to hear him say that those times he lost election, he was rigged out. So it means that there is no way election can be conducted in Nigeria that people will actually accept the outcome. It seems that, because I mean, if those 2 persons that just mentioning now could challenge results that we all knew was they lost clearly, but they still believe that they won, it means that anybody who loses any election, it would also be right to say that he won the election. But this isn't how things should go. I also want to talk about the fact, the role played by our colleagues, lawyers, in what transpires in electoral processes. I recall the last election, 2023, ahead of the election, we had situations where, you know, there's a timeline for introduced where the political parties will conclude their primaries, and there was a time they were supposed to submit the list of the candidates for the election, and this was done on the portal. So the leadership of the party have access to the portal, and they will just submit the names of the candidates and submit the credentials, the documentation for those persons. INEC was required to now print those documentations and display them so that if people have any objections about the details submitted by the candidates, they can raise issues about it. That was done. But after that period passed and close to election, sometimes even 2 weeks of election, some persons went to the court and claimed they had become candidates of political parties that they did not belong to. I know situations where people were in maybe PDP and APC. They contested for a legislative seat in the primaries, lost, and then close to the election, they ran to the Labour Party. And Labour Party gave them tickets without a process of primary that was observed by INEC because it was outside the period. And they now ran to the court, and the court, not minding the provisions of the Electoral Act, granted the order directing INEC to admit these persons as candidates in an election, sometimes 2 weeks of the election. And you know the effect this could have in the planning for the election, because we would have printed the ballot papers already and the result sheets that would not have these parties on the ballot for certain elections. And in fact, in one of the elections here in Edo State, we had to move the election to another date because we now needed to reprint some of those materials. So I also think that our colleagues, lawyers, we also need to look at the bigger picture of what is in the overall interest of the country when we are looking at the electoral process. It's not every time that you have a brief to challenge and make requests to the court that you must look at the bigger picture. Because I was wondering, why was it necessary for political parties at that time, so close to the election, they had not prepared to participate in those levels of election, but they were now pushing for it, and our colleagues were helping to take those matters to the court. And I also think that perhaps the justices also who gave those court orders and judgments may not have really looked at the bigger picture of the fact that a lot of those persons have been now admitted and will write court order by the side. They did not have the opportunity of their credentials being displayed for others to also scrutinize and raise issues if there was any issues about it. So I thought I should mention this. And I would like to conclude by saying this. And this is something I wrote as far back as 2014, and it's still happening now. I said the undemocratic nature of our democracy is often hard within the political parties. What we keep hearing these days are consensus. That was as far back as 2014 and is emerging now. Candidates who emerge through a process manipulated by a few big wigs of the parties. The leadership of the political parties mounts so much pressure on some aspirants, even cajoling them or buying them out of the democratic contest, just so that the anointed candidates would emerge unopposed or as consensus candidates. The so-called consensus candidates are usually the ones anointed by what I call the so-spiritual leaders or general overseers of the political parties, or at best, a cabal. For many smart politicians, therefore, they spend all their efforts trying to curry the favor of the general overseer or cabal. And as I ask, what do our political class, why do our political class so much at our election? We've just said that in virtually all the political parties, there was absolutely
that he will conduct the next election in those states with good conscience and in those states. But wherever you promise to conduct the election with good conscience, whoever takes over from you, or if you are still in charge, you have just promised them that you will do your best and you will conduct the election. Because we are ready. Now it's time for gentlemen to for us, to members of the floor, to ask questions. Because of the time limit and because another program, another lecture is coming up after this, we will limit the questions to 5. Okay, 3 from this side, 2 from this other side. And we don't want another mini lecture, just a straightforward question or remark based on. Now, Nanisel, first. Let us learn from Nanisel.
Ken Moses is my name. I will take your admonition, it's not a lecture. But starting from what the Rex said, we have argued a lawyer's duty is to present the case of his client. And I do believe that judges don't decide cases based on the larger picture of the nation. They look at the law as presented. After all, when I said it was due to a glitch, up to today, they did not think of the larger picture for the nation when they said that it is still a pending issue. I want to look at it from the practical side so that I don't worry. Now there are about 18, 20 political parties scheduled to conduct elections. And I do know that result sheets are carbonated, such that the presiding officer is supposed to write the results once. As you go away from the original, it becomes faint. We have had the issue in tribunals where your agent comes clutching his copy, it is almost blank. How are you going to ensure that that original, if you have 20 copies carbonated, copy number 6, 7, 8, 9, 10, they will have nothing on it. And then you come in and they will tell you that, sorry, there's nothing written on the result sheet, you can't use it. That is the practical thing that we are faced with. I'll not deal with the practical side of it, I won't bother about it. Secondly, arising from what happened in one of the matters we did recently, we have, as Mr. Ozzy said, 3 variants of result sheets, all certified by INEC, all bearing the same serial numbers. And you know what? They all differ from the certified true copy based on which the result was declared. Up till today, we don't know how many copies of original result sheets INEC prepared. Somehow, we have INEC certified by INEC, it tallied with the agent's copy, it tallied with the certified copy that we obtained from INEC. Guess what? It differs from the certified copy prepared by INEC on which the results were declared. All bearing the same serial numbers. How do you explain this? How do we know how many copies of result sheets you prepared? So that we are happy. Because at the beginning, my Lord, the first problem the petitioner has is to get electoral materials. You lose an election, you apply to INEC, it is another payday for most of the INEC officials. They will not give you the materials. They will tell you there's a designated official who will come and give CTC, he is never available. In a case, we have to offer to fly the person down from Abuja in the private jet. He couldn't come. That is the problem. And they say the man on ground, in order to streamline it, they are not entitled to give us certified copies. In fairness to them, we have had situations where those not authorized purportedly certified copies for INEC. So the reason may be there, but we have that situation. You go to the tribunal for an order. At that time, the tribunal is here to be settled. They will now tell you to take it, maybe the chairman alone will make the order. At the end of the day, 21 days, the clock is ticking. It is cast in stone. What do you do? So those are practical problems that we are faced with. I worry more about this issue of, I don't know how many variants of result sheets people are preparing, because to me, I go further than Stalin when he said the man that counts the vote. In Nigeria, it is the person that writes the form A. That is the one that is the issue. So that when you do that, and I don't know who writes for PCA, I don't know which one is the correct one, the signatures, the handwriting, they are different, but my Lord, the same serial number. And INEC certifies all. It becomes a problem. We had 4 result sheets, all certified by INEC. IREM certified for us, and then it was still a problem. So those are practical things. And when you say Nigerians, at the time people become despondent. You take all the effort, people spend money. It may not be due to you, my record. I know you are a very credible person. You know what, it may be beyond you. That is the truth of the matter. It's okay, it's good for the optics to give us assurances, but with due respect to you, they are beyond their capacity. We live it every day, and then it gets to a point where people are beginning to wonder, and that is becoming really dangerous, where people are beginning to wonder whether it is worth it at all, going through the process, because it is loaded against you. What my man there said is quite correct. At the time, I took a decision that I was not even bother going to the tribunal for a loser, because if you represent a winner, you don't need to do too much work. Just do that. But rather, the system is loaded against you in trying to offset an election that has been declared. The major tool we had was to go technical. In those days, it used to be fairly easy to maneuver. Now they have also now removed it, because those who are in the National Assembly, they are beneficiaries of this thing. And a lot of them have issues of certificate forgery. They take it out, they are now giving you stranded. That is the problem we have. So, in doing so, my Lord, let us look at the larger picture. And the larger picture is the electorate. It's okay to say people should vote count. We vote.
I plead to stand on the existing protocol. My name is Santos Owotumi. I will briefly mention 2 areas. I won't bother going to my judges so that it will take time. One is the frustration of the lawyer. It's from 2 ends. One from the court and one from INEC. The one from the court, I cite an example of Lawan's case. The Chief Judge of the Federal High Court issued a practice direction that electoral pre-election matters should be commenced by legislative summons. All lawyers complied. But when Lawan's case got to Supreme Court, it was a technical judgment. This matter is too conflicting for legislative summons. We all know before. We've been doing it by read. But when the practice direction comes, you got to go by it, whatever you get out of it. But in Supreme Court, that decision, that Lawan's candidacy was upheld on the fact that the matter started by legislative summons, which is in compliance with the direction of the Federal High Court Chief Judge. I consider that judgment as a judgment against the Federal High Court Chief Judge and not against the parties before the Supreme Court in that case. That is the frustration from the court. Then on the INEC side, the politicians know themselves. In the National Assembly, they know those whose style is to go and disrupt election in the territory of their opponent where it's strong. And they put it in the Electoral Act that once an election will not be conducted, this is disruption and disturbance. And the margin of lead, that is the margin by which the winner at the end of the process, the margin is lesser than the number of people who are disenfranchised because of disruption. Then the election is conclusive. The Electoral Act provided for it. But the people who are the chief of disrupting election in areas where they are not popular went back to INEC to get INEC to do a guideline that modified that position. And INEC provided that margin of lead cannot apply where the disruption is in bad faith, that is caused by either the political party, their agent, or whatever. Is there any disruption that is not in bad faith? The point is, when a disruption is noticed and the law says reschedule the election within 7 days, the expectation of INEC, of the lawmakers, is that in 7 days you can mobilize all the military forces to go and conduct that election and all the staff of INEC. You can even conduct the INEC can become POT for that particular one because it's a few one. But INEC sat in their office and made a regulation that when that disruption, their investigation shows that it was deliberate. Is there any disruption that's not deliberate? That they will now declare the election, despite the fact that the people who disenfranchised, maybe there are 10,000 people couldn't vote, and the man who won by 1,500 votes. That is what they call margin of lead. Once the people disenfranchised is more than the margin by which the winner at that stage wins, then you must not declare a result. But I didn't nullify that. That is why I said the lawyer and the people have to cope with that. That is a direct violation or negation of the provision of the Electoral Act. I have the sections here, so I don't want to waste time. Thank you very much.
Okay, the past channel.
Thank you very much, Mr. Chairman of the session. My own would just be 2 or 3. First, on the issue of party primaries. The resident electoral commissioner talked about those primaries and how the parties have, after weeks of primaries, they are able to declare results. I know by provisions of the law that INEC observes or monitors these primaries. And I believe that when INEC sends officials to monitor the primaries, they monitor up to the declaration of results. Results are counted. If you are there to observe or monitor the primaries, people have voted. And the way we see them voting is by either lining up behind your candidates and all of that. And why is it that at the end of the day, as at today, INEC will say they do not know, or they are saying they do not know persons who have emerged from the primaries they observed? What then is the essence? What then is the essence of INEC's presence? Because you see the political parties today, the factions in the party coming to say, oh, our own is the authentic one, because INEC observed our primaries. INEC did not attend or observe the other one. And that is even a ground for people to say, oh, this primary is the valid one, the other one is not the valid one, because INEC was present. So what is the essence of having INEC monitor primaries if at the end of the day it is still there for the political parties who may now decide to put forward candidates who did not actually emerge from those primaries in terms of higher votes? Now, I have always believed that Nigeria will not make good progress unless we get our electoral systems right. Politicians will continue to do what they are doing, irrespective of what the electors want or think, unless and until they know that our votes will count. Now, for me, the problem is both legislative, executive, and judicial. Even the executive, their own is to circumvent. They just watch. Our laws are not made to favor the electors. First, unless and until the cerebral access, we must go electronic. But the cost of who make the attempts to go electronic look like a waste of time. It's a problem. Now, then the cost again, I've said this concept of substantial compliance. Somebody has come to say, oh, election, there was rigging, there was manipulation, there was this, and people say, well, there is substantial compliance. In other words, there was no absolute compliance. For me, I think our legislators should look at it. We say election cases are sui generis. They are special. Time is fixed. Different things are put into the electoral tribunals and election matters. Why can't we, for instance, take the burden of proof from the petitioner to INEC? Now, if a candidate questions an election at all, let INEC be the one to come and say this election was done in accordance with the law, because they have all the materials. They do not put the burden again on a petitioner who is crying that, oh, I have been defrauded in the field, results have been manipulated. You said you should go and get the same results from the umpire. If, for instance, I question an election, let INEC have the burden of proving that that election was done in accordance with the law, the election was free and fair and credible. It is only at that point that we'll begin to get it right. Because for the presidential election, for instance, the law tells you must bring agents, you must bring persons from the units. You have 21 days to file. You are going to front-load the statement of these witnesses. You are going to come and call them when you are giving at the pre-session. You are giving a number of days to prove your case. How will that work? And that is why till tomorrow, till 30 years time, if these laws remain the same, nobody will be able to. And of course, my next speaker said I will not represent those who lost anymore. That is the position, because you will find it so difficult to be able to turn election results in this country. That was our big presentations. Thank you.
The first question. Okay, this is the last question.
Thank you for the privilege, my lord. My name is David Maduko. I want to take a different perspective. Just some comments. It's a fact You know, when we talk all these things about elections and activities that take part in the elections, it's a fact that we abandoned the parliamentary system of government in 1966. And we have been mispracticing the federal system of government from 1979 to 1983, and from 1999 till date. I don't want to go into all the elections that have taken place, though a large proportion of the population agree that the 1993 elections had some form of freeness and fairness. I think we start thinking of, you know, going back to adopt the parliamentary system of government. Since the federal system of government has failed us in all these elections, maybe one of the things we should consider. Then secondly, my lords, Section 64 of the Ghanaian Constitution talks about any Ghanaian citizen can bring an action on the outcome of an election. I have not studied the new Electoral Act, so you'll excuse me on that. I think there's a provision in our old act that says it's only the people that partake in the election that can bring an action. So we should begin to look at things like this. There are people who saw things go down in the election, whose evidence will be intrinsic to, you know, sorting out what took place in that election. And we are excluding those set of people out. So it's about time we start looking at widening the margin. We look at the example of Ghana's constitution to also widen our margins. Thank you very much.
Let's give the last chance to the former members of the Judicial Service Commission.
Thank you, William. I apologize for coming late and being the most of the lecture. There are some interesting points which I needed to hang on to way back in last week. Mr. Efanga. I was asking a colleague there, was it the Electoral Commissioner for Edo State? He said yes. Oh, I said, oh, nice. I've been looking forward to ask you one or two questions. First of all, is the fact that based on the last statement you made that in the interest of the general public and of course the nation, let me add, based on the last election, the major election, governorship that you conducted. Okay. Because I wanted to find out if you were the one who conducted the election where the said person is Uncle Wiki's cousin, whether you are Uncle Wiki's cousin. Okay, if I know the rest of the case.
Finally, I think we have to listen to the responses from our resource persons. What do you want to say about the questions they asked? We start with the former attorney.
Thank you, Lord. Fortunately, most people do not direct their questions to me or my presentation. But I think there are one or two quick issues I would like to respond to. Mr. Zabo, I think the rep has already answered you. I think it's clearly mistaken as a rule of INEC in terms of political party primaries. First of all, in terms of registration of political parties, Parties in 1999 were registered based on the decree and guidelines issued in 1998. And that has changed. Since that time, the Constitution has come into force, and the Constitution has laid down procedures for regulation of guidelines. And rather than what you said, I think you term executive tyranny. I think in this particular context, it is completely misplaced. Because recall that in Musa against INEC, the PRP and Musa and everybody went to court, it got all the way to the Supreme Court. And the Supreme Court said you cannot impose conditions outside those stipulated in the Constitution. And the registration of political parties is probably the easiest thing. It's easier than registering a private company. It's easier because stipulated there. What you need is that you have members from 24 states, 2/3 of the states. You have the headquarters in Abuja. It doesn't say you need offices in any state or in any local government. So the fact that the political party does not have a state, they say it's not a prerequisite. INEC can try to put guidance that you must have offices in 2/3 of the states and local government. Supreme Court struck that one down again unconstitutional. So you cannot go beyond. If you want to call it judicial tyranny, you may use that term, but it's wrong, I think, in context. You go according to what the Constitution says. Then primaries as well, again, it's misplaced. INEC has no role in primaries. All the law says that you should give INEC minimum 21 days notice. The law also says that in terms that if you don't give INEC 21 days notice, then that the primaries are invalid. You can be validated. But you do not dictate what happens in the primaries. The only thing INEC does, and that's subject to controversy now, is limit the time. No time is limited for conduct of primaries in the Constitution. No time is limited for conduct of primaries in the Electoral Act. So INEC felt that we can now issue guidelines limiting time for primaries as long as the two judgments, they agree on certain basic things that 29.1, time for submission of list of candidates, you do not play with that because that has been fixed by the Electoral Act. Where they disagreed on, one of those judgments said that you, because no time has been limited in the Electoral Act or in the Constitution, INEC has the power to issue timetable guiding when it should be conducted. But the previous judgment said no, you cannot because so that I think Court of Appeal will settle that. But the INEC rule, INEC has no right, I think that's what you said, INEC has no right to just take the winners of primaries and put on the ballot. Part of the reform prior to now was that that should be the case. But the law is different. If you look at the Electoral Act, Section 29 was it's not different to 120 days to the conduct of the elections. The political parties that wish to sponsor candidates may submit the list of candidates. So the director of the political parties for the political parties to submit the list of candidates, not for INEC to take from the primaries and go and submit that. So all those who are suggesting that that should be done, if you want to do this electoral reform, change the law. If you say that immediately after the primaries, the INEC observers should just, or monitors should just take the results of winners and go and put on there, that is what should happen. The last thing is on transmission, and I'm surprised how many questions were asked on this. Now, we should pay attention to this. If you look at Section 60, subsection 3 of the Electoral Act, it says that INEC shall transmit, the presiding officer shall transmit the polling unit results straight from the polling unit to the IREG, so electronically transmit to IREG. Section 60, subsection 5 of the new Act says that for purpose of collation, INEC to transmit the results, the presiding officer shall transmit the results to the next level of collation. It doesn't say to any portal to IREG, to the next level of collation. Whereas in subsection 3, it says that electronically transmit. In subsection 5, it just says transmit. It doesn't say electronically. So we should watch out for that when we start presenting our petitions. So it's a very fundamental thing. You know, statutory interpretation is in the same section, it says electronically transmit in section 63. In section 65, it removes the word electronically transmit. So we are back to where you are on transmissions. So I think basically that is what Section 88 says that failure to comply with provisions of the Act leaves the party without candidates. So you must comply with Section because it's only participants who participated who can actually have locus to challenge where that has not been done. So I think that's all we have to say. So instead of those electronic transmission risks Section 63 and 65 and see what is needed. If you want to change, you must go and amend the Act of State to the electronic transmission. We have not moved one judge from where we're in 2022. Thank you so much. And as for data people, I don't think it's the show of whether it's a parliamentary or it's a presidential system. Here we're discussing elections, the process of selecting people, whether it's a presidential, whether it's a parliamentary system. And you talked about Section 64 of the Ghanaian Constitution. There's no problem about that. If you read Egolon against Obasanjo, in the Act in 1998-99, gave locus to any person who feels is qualified to contest the office. So Egolon went and contested the office. So Nasota had in that case. The Supreme Court said no, not only must you show, you must also show how you were qualified. You must put your age, your nationality, you must believe how you were qualified. So it was restricted and here already we have each side we have 1,500 more petitions. If you open the thing for everybody, you are likely to encounter the floodgates and without giving them opportunity. And INEC does not, in the last election, several elections, INEC does not follow limited. Even with the discrepancies in its own production, the body still, people that cause the body shifted, the body still does not shift. The same rest of you. So as Sergeant said, you have three different results certified by the same body, but it does not come to explain which is the number one. Use one to collate and not the others. These are things that we are to the mind. Thank you, sir.
Okay. What's the chief? Thank you, sir. Like my very senior said, on this issue of INEC not involved in party primaries. You know, the last decision of the Federal High Court on the quarrel between parties, on the party status and their leadership. The parties did not appeal, but INEC appealed against that decision. If INEC appealed against that decision, then INEC is a determining factor in the party activities and the leadership of the party. Then two, the one that was raised by my learned friend Maduku about the presidential system of government and parliamentary system of government. The name given to it is of no moment, but the participants, those people that are involved, they are the main, unless they are properly circumcised. the same issue will continue to come up. When you go back to parliamentary system, and the same people are going to be the participants, the issue that have been there for the presidential system now will carry over to that point. So that is my own view about it.
Yeah, okay. I listened to the contributions, the presentations, the questions, and the answers. But I think it's beyond INEC. And listening to the fireworks against the INEC rec, I actually feel for INEC, but the truth of the matter is beyond INEC. We as a people, what have we done? Did you see the primaries conducted by the other political parties apart from the ruling parties or the main parties, where during a process of conducting a primary, someone is counting from 10 and he gets to 200 and he gets to 2,000 and that is being aired. It is a national disgrace. And that is not INEC. That is us as a people. In advanced climes, we have two philosophical political thoughts. Is either you are a rightist or you are a leftist. In Nigeria, you are a rightist, a leftist, an optist, a downist, but everywhere. No political ideology. You can be in APC in the morning and be in PDP in the evening. You can even be in the PDP and be contesting elections in the APC. And you can even determine what is happening in APC while you are in PDP. there's a need for a reorientation. There's a need for us to, there's this insatiable quest for power that has to change. Otherwise, we will remain in the same spot we are, irrespective of the electoral reforms we talk about. Thank you.
I think at this stage we have to draw the curtain. Thank you very much. Yes, I took note of the question asked about by the senior advocate about the carbonated copies of the results. And something I've observed myself even before I joined INEC. It was worse when we had up to 80 political parties. But now that we have fewer political parties, in some of the elections you know that you don't have all the 18 or 22 political parties contest. And so it's easier to feel that. But we also instruct the presiding officer in the polling units to try to, write it in such a way that the copies on them will also appear. And it's also possible for them to, after writing the first, maybe the first one, open up and then write again on a subsequent one so that it appears. But the point is, but the point also is that apart from the early pages, sometimes the agents of the parties also take a snapshot of the early copies, which are still clear. And that is why you can also have the one-way iron. Okay? Now the question you asked about having 3 different results certified and it goes to the court. I expect that it was the duty of the court to have taken a decision based on that. Which one seemed to be the most authentic? That's no. Yes, look, the truth of it is that, like somebody said, there are lots of things that play out in this. It's possible that somebody was compromised. That's the truth. And you end up with, there was an election where INEC brought its own copies of the results, right? And then the police brought a copy of the results they claimed was for that election, which was different from INEC. And the court accepted the word of the police. It has happened before. So it's about us as a people. What's the quality we bring to the work we do? Somebody was trying to ask me direct questions about the last election, and thank God that has been explained. The election I conducted in Edo was the general election 2023. So if you have questions about how that was conducted, I can answer that. Thank you. I thought probably the DS was anything from the bench? I am making my remarks to be very, very short. The president has just given us what should be a kind of a judgment. If you have 3 forms, conclude yourself. On behalf of the members of the environment here, the members of the NABA, the organizers in the Nigerian Bar Association, the Lion branch, which I'm very, very proud of. I would like to draw the importance of this program based on what INEC has just said.
Thank you, Lord. We perhaps, very sorry, sir. We will do the vote of thanks for just 1 minute and we'll do the photo session. and the second session will be instituted right away. The panel will be constituted. The camera, Esquire, Tom, Esquire, please, people of hands. Please, can you all sit there?
Sorry. I don't on behalf of the Life Club want to thank the presiding judge of the Federal High Court, Benin, Honorable Justice B.O. Quadri, for chairmaning this session. I want to thank the keynote speaker, our own former Attorney General and Commissioner for Justice, Oluwole. We thank the INEC Commissioner that has graced this occasion today. We thank our own Mr. Osaimabo for gracing this, and also our own Osero Akinde. We thank you all for making this session very, very engaging. We thank you all. We thank my boss for being here with us. We thank all our colleagues, our learned SMs, and senior colleagues, and other members of the Lion Bar. Thank you all for this session. Thank you so much.
Thank you very much, Vice Chairman. May Lord the presiding judge, Federal High Court, we appreciate you. The panelists, the lead speaker, Oluwole Osafe, who is in Esquire, great content. The other great, spectacular. Thank you, sir. Thank you, our dear photographs have been taken already. Please, can the bar also still join? Okay, the chairman of the bar is already here. We can still do the documentation, the photograph. It's necessary. Please, on this way. The Lord, sir. Please, quickly. The photograph. Sorry. The photograph. The chairman of the bar is here. Yes, sir. Elder, please, the chairman of the bar is here. I think the INEC rep. The INEC rep, please. Uncle Gordon, please. Chairman of the bar is already from the camera is going. The photographers, please. Can he mostly a senior advocate of Nigeria? Milord, please. This is an expanded and more appropriate photo session. Thank you. Thank you. Are you okay? Thank you. May we be seated for the second session now. May we be seated for the second session right away. The chairman of the second session. We are taking the citation already. Planning committee, please, can we get everyone in and everyone seated, please? The chairman of the second session is no other. Can we have everyone in now? Virtually all the participants of the second session are around now. We want to announce that immediately after the second session, lunch will be served here in the hall. Immediately after the second session, lunch will be served here in the hall. Can we come in immediately, please? Please, can we decongest the... Can we decongest the front row, please? May we be seated, please? May we be seated for the second session. Past Chairman of the PAC, Organizing Committee, Planning Committee, get them seated. Hello, sir. Please, the second session is about to go. Daily Abino, Esquire. Please, we need your reverend presence now for the second session. Please, may we be seated for the second session. Distinguished gentlemen, members of the press security, other protocols observed. Please, can we shut this door? Shut the door. Thank you. And we'll be seated now. The chairman of the second session, the topic for discussion, please, our PAC chairman and my dear brother, Santos Owotumi, please, can we be seated now? Douglas Obankwa, please, I'm your full name. Can we be seated? I'm mentioning names now because I'm not listening. Can we be seated now? Please, those at the back, warm your seats, please. Uwa, Tabo, Treasurer of the Midwest Bar, be seated. I beg your pardon. Uwa, let me please be seated. Thank you. Distinguished gentlemen, academics and resource persons, press, security, invited guests, particularly from the echelon of the administration of this state. They have said that they want anonymity but observing the proceedings here. The wife of one of our great midwives of this state in terms of administration said she has come particularly to observe that she doesn't want to be introduced, and we so respect your decision, but as a matter of anonymity, we still say welcome. Thank you. The second session is about to start, standing on the existing protocol. And we give glory to God for the first session. And we say, Almighty God, we apologize. We didn't pray before we started the first session. Please forgive your children. And thank you for your grace and mercy and compassion. In Jesus' name, we are giving thanksgiving. And somebody will say loud, amen. Second session is justice for sale. Who truly pays the price? Justice for sale. Who truly pays the price? That is what we want to interrogate under the omnibus session of reforming today, securing today for tomorrow. And the chairman for the session is no other than a distinguished practitioner, a man known across the ecosystem of the legal profession and particularly the MBA. A first in time standing national vice president of the bar. Our distinguished guest is a seasoned legal practitioner and former national leader of the Nigerian Bar Association, with over 3 decades of active practice in litigation, public interest law, and professional governance, called to the Nigerian Bar 1990. He has built a reputable legal career based in Warri, Delta State, the oil city, where he has been actively involved in private legal practice and institutional service. He has held several leadership positions within the Nigerian Bar Association, including serving as chairman of the NBA Warri branch, vice chairman of the branch, and as a member of the National Executive Committee. At the national level, he rose to serve as the first vice president of the Nigerian Bar Association between 2020 and 2022, where he contributed to policy direction and the advancement of the bar's institutional objectives. He also served as chairman of the NBA section on public interest and development law, NBA SPIDER for acronyms, reflecting his strong engagement in legal reform and public interest advocacy. He remains widely respected with the Nigerian legal profession for his leadership within the bar, his commitment to institutional development, and his contributions to public interest law, where he currently thrives professionally, calling attention of institutions and government to the need to respect in the people in whose best, in fact, the sovereignty lies. We are very humbled and privileged to make welcome our dear brother, a restless intellectual, a veteran in the profession, a son of the Edo soil, residing in the oil city. Make welcome John Aiko Martins, Esquire, Chairman of the session. In fact, he's really good oil. You can see his body changing always. Please, can we give this gentleman? We are proud of him. A good Delta. Angel for the Cadillac. That clap is lacking at that number. Didn't hear. Please celebrate it. Thank you. The lead discussant in this topic, Justice for Sale, who today pays the prize, is another very erudite scholar. Permit me to say, great jurist. He's done a lot in the profession. Our distinguished guest is a senior advocate of Nigeria with over 2 decades of active legal practice, widely experienced in litigation, constitutional law, public interest advocacy. Called to the Nigerian Bar 1999, he is based in Warri, Delta State, where he has maintained a robust litigation practice through Kunle Edun and co-handling complex civil, constitutional, and governance-related matters. He has served the Nigerian Bar Association in several leadership capacities, including the National Publicity Secretary of the Association, as well a member of the National Executive Committee. At the branch level, he has also held the position of Vice Chairman of the NBA Warri branch and has chaired several committees focused on human rights, pro bono services, public interest litigation. He is widely respected within the legal profession for his commitment to the bar leadership activities, his contributions to public interest law, and his active engagement in strengthening institutional accountability within the Nigeria's legal ecosystem. We are privileged and humbled to make welcome Leonard Seal Olukunle Edo, Senior Advocate of Nigeria. Can we clap, please? Loud. This man you see is an embodiment of several things good. That clap offering is not sufficient for his personality. Thank you. I have personally known him for quite some time now. Erudite scholar of international repute, great orator, and from the great University of Benin. He is our distinguished guest a professor of history and international studies at the Great University of Benin, with extensive academic experience in African history, international relations, governance studies. He has contributed significantly to scholarly discourse on nation building, political development, and the dynamics of governance and security in Nigeria. Over the course of his academic career, he has engaged in teaching, research, and public intellectual contributions within and outside the university system, focusing particularly on African historical development and contemporary issues of government and policy. His work reflects sustained engagement with questions of state formation, democratic accountability, and institutional development in Nigeria. He remains a respected voice in academic and public discussions on governance, security, architecture, and national development. We are privileged. This is an abridged version of this distinguished personality. Just for want of time, please make welcome the very erudite scholar, Professor Eraibe. Great orator, giving an oratory clap innovation. Thank you. My prof, welcome. Also my teacher. I want to please someday add. A great man is coming to take his seat. Give him a great clap, please. Thank you. We are indeed very humbled to have a great academic in our midst. He has contributed greatly to the ecosystem of the academia across Nigeria and internationally. Our distinguished guest is a professor of law and a senior academic administrator at Benin University of Okada, with extensive experience in legal education, criminal law, scholarship, and academic leadership. He previously served as Dean of our area, our College of Law, where he provided academic administrative leadership in the training and development of future legal practitioners. A member of the Nigerian Bar Association, Benin branch, since 1993, he has maintained active engagement within the legal profession alongside his academic responsibilities. He is also a notary public of the Federal Republic of Nigeria, reflecting his standing within both academic and professional legal sectors. His academic work focuses principally on criminal law and the administration of criminal justice system, and he has contributed significantly to the legal education and institutional development within the Nigerian university system. We are honored and humbled to make welcome great academic, erudite scholar, jurist, the Deputy Vice Chancellor at the Benin University of Okada, Professor Osarati George Izebua, Esquire. Can we give him a big clap? Thank you, sir. I needed water, but I can move. Pardon me, please, for my idiosyncrasies. The next gentleman is a man of international stature, represented well this state, Delta State, Nigeria, creditably. I don't know how to put him in a rap, but let's do an abridged version of his citation. May you be upstanding, sir. Reverend, thank you. Our next guest is a distinguished guest in the leading anti-corruption advocacy and civil society leadership, with extensive experience in governance reform, transparency advocacy, public accountability initiatives in Nigeria and across Africa, and indeed internationally. Is the executive director of the African Network for Environment and Economic Justice, ANEJ, a prominent civil society organization based in Benin City focused on anti-corruption, environmental justice, and economic governance reforms. He has played significant roles in national and international governance frameworks,
including participation in the Open Government Partnership, OGP, Nigeria, Anti-Corruption Working Group, and service within the United Nations Convention Against Corruption, UNCAC for acronyms, coalition, where he was elected to represent the Sub-Saharan African region on its board. I thought we should clap for him. He has also contributed to regional governance structures under the African Union Advisory Board Against Corruption. His work spans issues of illicit financial flow, asset recovery, and institutional transparency, positioning him as a key voice in civil society-led accountability reforms in Nigeria, Africa, and internationally. We are privileged, sir. He is a man of God, a reverend of the Most High God in the body of Christ. Reverend David Ugolo. A resounding round of applause, please. My dear Chairman of session on this very mighty and demanding topic for engagement, I want to seek your leave to please quickly do a 2 minutes as a matter of the Midwest Bar. The Midwest Bar is a conglomeration of the various bars from Edo Delta, assembling as one common front as a body, and even representing this catchment area within the framework of the practice and profession to represent us nationally. Therefore, it is a key bar and institution from this level to the national. And that is why we seek your leave, Mr. Chairman, and discussants to please call on the representative of the chairman of the Midwest Bar, Ama Etuwe, senior advocate of Nigeria, here represented by the secretary. We are proud of him, and he's from here. He's our own. I hope he's around. I saw him a while ago. He was here. I hope he has not tiptoed. Please look for our dear Deposela Okifo Esquire. He is supposed to deliver the goodwill message. I interacted with him a while ago, and I saw him just a while ago. But we welcome them. Anytime he's around, we will take that, because the law abhors any lacuna or vacuum. Therefore, Mr. Chairman, may I seek your leave to hand over the microphone back to you, your remarks, and let us invite the session. Thank you. A round of applause for Mr. Chairman and family. Thank you.
Thank you, my eminent Master of Ceremony. You are very wonderful. You have a way with words that you just get carried away. I want to welcome you to this section on behalf of the chairman of the branch and members of the branch. I welcome you all, and I want to appreciate you for being here, because usually a lot of us will just go home for one thing or the other. But thankfully, the board is not empty, and we are doing the branch very proud. May I recognize the chairman of the branch, Mr. David Osifo, who was my roommate in the university. We did so many things together as boys. Now we are men. Yes, now we are men. I also want to recognize Mr. Ken Mozia, Senior Advocate of Nigeria, who is our guy. And I want to appreciate you for still being here. If you look around you, you're the Senior Advocate and probably the most senior lawyers at this present. Senior lawyers always tend to go home, but he's still here with us. So, a round of applause for him. The chairman, past chairman, Mr. Dosage, you are also welcome to the section. Now, the section is, the topic for the session is well known to all of us, because we don't practice as a lawyer, that you don't understand what this topic is all about. But even if you are socially active, you also understand that this topic is a very important topic in the administration of justice in Nigeria. In Nigeria, the administration of justice is just like a well-prepared soup or stew. For those who live in donuts, so there's a ball, very tiny. Once you fall into any food, it spoils everything. That is what the situation we have in Nigeria. We have a beautifully well-crafted administration of the justice system. The laws are good. We are well taught in the law school. Everything is just okay. However, there's one simple bug that seems to cause confusion everywhere, which is the bug of corruption. It has spoiled our good administration of justice. So today, the law would have taught it considered to bring up this topic and assemble a panel of experts to dissect this issue, either from experience or academic. But this issue is not academic. It is what we all know. And I'm very sure a lot of us will have one or two instances on this issue. I'm highly privileged, therefore, to chair this section. Just before I call on this speaker, who we all know, just like it's my brother. In fact, except we are not in the Nigerian Bar Association, but you know that, in fact, wherever I go, in fact, if it's not present, they ask me, where is today? If I'm very sure they also ask that question, where is John? Where if we are not together, we are just together. So yes, I'm asking together here today. No. You don't do anything together. So I think I already know exactly what is going to tell the house. I don't expect that's what I'm going to say. And I also want to make mention of the fact that as a professor of history, right? But a lot of us don't understand that law is history. Everything you repeat by way of authority is history. So history is very central to the practice of law. But unfortunately, history was taken away from there is some standard. Yes. So I'm actually very happy that we have this one historian with us today. So I think we are going to give us a one perspective of a lot of issues that has been placed before the house. Now, let me just set the ball rolling. I'll just say they have just did a few or a small story. Very recently, it happened less than a month ago. I was a defendant in a case. And after we filed our statement of defense, we raised issues of law and filed a motion to set issues of law down for hearing or jurisdiction, particularly on the issue of limitation that the suit was called by statute, the statute. Now, we filed our written addresses. Matter set for, we adopted, matter set for ruling. First day, adjourned. Second day, adjourned. Third day, adjourned. The fourth time again, adjourned. Then I called my client and they come here. I had a very strong feeling that this judgment, this really is being adjourned because the Judas has been reached or wants to be reached. Have you reached this man? Tell me confidence. He said, yes, he has reached the man. I said, okay, if you have reached the man, I expect you to give ruling in your favor as early as possible. So it's not giving the ruling simply means that the other side has reached it. Or you want more. Who said that? I didn't say I practice everywhere. I go to Bar, I go to yes, sir. Yeah, for real. I said, yes. I said, go back to him. You didn't go to him, go back to him, find out what he's looking for. But there's something he's looking for. I don't know. You transacted without my knowing. But this adjournment as a bad guy. I know something is alright. And well, ruling has been delivered. Let's say anything. But the fact is, he actually told me, he actually confirmed that he reached the Julius. Very shameful. My brother played at USA. The floor is not yours. Thank you very much.
Well, thank you, Chairman, my blood brother. As a matter of fact, anywhere I go, like you did say, they ask me where Jonathan Martins. Incidentally, let me just say to the gathering here that when July Martins was the chairman of NBA Warri, I was the chairman. I was the person against all protestations that he made the chairman of the NBA Warri Public Interest Litigation Committee, and that was in 2016. Am I right, chairman? 2014, against all protestations by the leaders of the bar. And I think that was where I started the journey of my public interest litigation. So, please permit me, let me do some housekeeping shots by giving kudos to some of my leaders. One of them is present here. When Santos was talking, he said, "That is my boy." I said, "Okay, Santos cannot be your only boy, I'm also your boy." I'm talking of the person of the evidence sake, Kebozia SN, who incidentally I've been in matter with at High Court Arbor, and learned a lot from him. And I pray that I will win. Okay, let me make that case. Thank you, my leader. I represent the chairman of the branch, my very good friend, and the immediate past chairman. And also, Osato, you are here too. You are aspirant for Assistant General Secretary. You are welcome. And Ato, thank you very much for the accommodation. I didn't want to come here initially. I didn't want to. But I I'm sorry. I did not want to come here because of the vast state of roads between Warri, particularly from Cocoa Junction down to Warri. I told Santos several times, please, I will not make it. Though I was here 2 weeks ago, you understand, a guest. But I had to come because it was an NBA human rights event. I needed to come. So, but I okay, after God questions, I said, okay, the only way I can come is that is I want to. I'm sick, but I'm not started heading the money. I will show you the way. But I said, okay, I will take a flight from Warri down to Abuja, come to Benin. My leader has got into that state. My chairman just told me of what he encountered when coming to Warri, coming to Benin today. He had to pass through the bush paths. So it's quite unfortunate. So thank you very much. I recognize everyone present. This topic, I was telling Ato that look, why did you choose me to be the lead speaker on this topic? Is it because I talk too much? He said no, but you know you always speak your mind. I said okay. If I come there, I said okay, many of the judges are thieves and criminals. He said arrest me. He said no, that will not arrest me. I said okay. But please, whatever good things I say here, if I at the end of this my intervention, if I do very well, please. The kudos should go to leaders like Trustee Alege SCN, SCN, and my Ogaye Ken, because they are SCN. But if at the end of the day I is fired, please send it to July Martins. So with that, justice was saying, who truly pays the price? That was a topic that if we start talking today, you can finish it. It's not possible. I listened to the last session. I was present most of I think half of the time. The electoral matters that were discussed. And we all agreed that our electoral system is really, really bad. And it's a systemic problem. And that's part of the issues we are discussing today. Who are those paying the price? We know we are the lawyers, we go to court, but are we actually the ones paying the price? We may say yes, we may say no. The courts that deliver judgments, are they also victims? Some of us may agree, some of us may not agree. Even the people that are in politics, that today they will say yes, tomorrow when they are out of power, they will say no. You know, they don't change. Are they also victims? So, this is my topic. My paper today will speak to these issues. And I will try as much as possible to talk to the papers without necessarily being unnecessarily academic. I'll try to do some, delve into some practical experiences. But please permit me to just do some intro. According to my law, on DJCA, in the case of UCH against Board of Management, against Murakio, citation provided, Aristotle defined justice as a concept of what is lawful, fair or equal. He classified justice into two, distributive and remedial justice. He defined distributive justice as injustice arises when equals are treated unequal, and also when unequal are treated equally. To him, just action is a means between acting unjustly and being unjustly treated. The common saying is that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased. Now, we are talking about a situation where justice itself, the integrity of the justice system, and the term justice for sale refer to the following. These are the various connotations we may give to it. One, judicial outcomes are improperly influenced, deviating from the merits of the case and the details of law. Two, legal processes are manipulated. I'm coming to that. Some of us wait. Not to achieve justice, but to gain an unfair advantage, frustrate opponents, or prolong proceedings. Three, access to justice becomes disproportionately dependent on an individual's wealth. Yes, but that is true. Social standing or political influence, rather than on the inherent righteousness of their cause. As a public interest litigation lawyer, I am experiencing, John has experienced, and some of us here have experienced. Please permit me, Mr. Chairman, to give special kudos to President Erdogan with respect to the judgments that he obtained in the, I think, one that had to do with Freedom of Information Act. Yes, that case, I actually filed one in Delta State 2018. I saw for some information from the Pigris Board, both Muslim and Christian people of Delta State, that they should avail all the votes that the Delta State government had provided for them. They refused, so I went to court on the basis of the FY Act. Expectedly, the court actually agreed with me and entered judgment in my favor, but at the court of appeal I lost. I lost because my lord, I didn't mention this name, but the case is reported in Law Pavilion. I just said I was actually a busy body, and the case was dismissed. So I give kudos to President Erdogan. He helped us to expand the doctrine of local standard in public interest litigation. So, now going further, I've been with JCA, now GSA, in the case of Kolawole and others against Alawi. Define the term miscarriage of justice, which we already know, so I don't need to define it, we all know it, so I will skip that point. The corrosive phenomenon manifests in various forms, including bribery and judicial corruption, direct or indirect attempts. Of course, we've said much about that. Section 52 of the corrupt practices and other related offences are provided framework for addressing issues of corruption. Of course, we know much about that. Forum shopping and procedural abuse. This strategic manipulation of court jurisdictions or procedural rules to secure a favorable outcome, often at the expense of fairness and efficiency. The recent, permit me, Mr. Chairman, after the chairman was one of the parties in the case, the tinted glass permit case. That was the matter that, I think at the NEP meeting, the APC NEP meeting, the APC NEP, Chairman, you were there at Enugu. So NEP resolved that my very good self should lead the team to challenge the federal government policy or the police and police of enforcing the tinted glass permit. So we filed action at the federal High Court Abuja. Filed action at Federal High Court Abuja. Actually, when you know that a judge has been breached or is already biased, from my little experience, you don't need to waste time. The first 2 times I appeared in that matter, it was like 4 minutes. Immediately after that, I stopped appearing before that matter. And I reached out to the president after I was sick. I said, look, this judgment is, when the judgment was delivered, it's not going to be in our favor. So I told him, he said, okay, what do you advise? I said, look, as a proper worry boy, if the bird wants to think that he can fly higher, I will tell the bird that, look, I can shoot better. So I called the Veritas Force and I said, okay, we need to find our own action, not NPA again. So we find our action at Federal High Court. He said he was going to be the plaintiff and made himself available to be the plaintiff. On the basis of that, many of us don't know what actually happened. On the basis of that, it was a tough argument for us because on the day of the hearing of the motion experts for interim judge, it was very tough. The judge was actually reached. I shall not confirm was reached. I don't know how they were able to know that we are already fine, but they had to getting their information. So the argument, it's not almost 1 hour or thereabout, but at the end of the day, we are able to convince the court that if I will not grant interim injunction or restraining the police, at least Madam can make an order, something like for them to come and show us, and the interim that is maintain status quo. Let us say, evidence in Cambodia. So the court brought into that. So the issue now, after I made the order, now what is status quo, anti the law, or what? So I thought, why they are discussing all those, I said, President, let us go. So the IGP now called for a meeting. The chairman was there, I was there. So it was another very tough meeting. And that is why I can say confidently that some of us, live brother, are embarrassed. We are embarrassed. You see situations where lawyers will be speaking probably because they are being paid or they are enemy. So to cut the long story short, thank you very much. So it was an argument that the police now resolved that, okay, they will issue a statement stopping the enforcement of the tinted glass permit. That is mostly due to the close of myself, the first Vice President Emeritus, and Alpha Musigwe. So now we are not satisfied with that. Don't ever trust the police. We're not satisfied with that. If you recall, a month or 2 thereafter, they now decided that they were coming back. And I called one of the right activists in Warren. So based on that, okay, because we got an order which people were interpreting to favor you, okay, we now file this own fundamental right action. So that can never be an abuse of consciousness, really, because you have the right to file such action because you are aggrieved as an individual. So now we file it, and that was where we were able to get the substantive orders restraining the police from the High Court of Rwanda, and that put a stop to that rubbish. So now they turn it as forum shopping, but that can never be forum shopping. You understand? But forum shopping is what many of us engage in. You know very well that, in fact, many politicians do engage in that, and many lawyers do engage in that, and we know what it entails. That's part of the issue that we are talking about. Now, the net tactics by lawyers, unequal access to competent legal representation. Let me say, I want to use opportunity to speak to this issue. This time, I'm going to make reference to the rules of the Senior Advocate of Nigeria Privilege and Functions Rules 1979. This type of disparity in the quality of legal services available, where West takes the caliber of advocacy, thereby skewing the playing field. Now, by virtue of an essay cannot appear before lower courts, the magistrate court, the district, all these customary court, you cannot. But you can actually appear before a magistrate court in terms of when you are going to prosecute a criminal case, or you are appearing. In fact, it was even contested that because I had a case in Warri where I appeared with the fiat of the AG and the magistrate court to prosecute a very big case in Warri. You understand? And it was very contested, but eventually the magistrate court agreed with me. But it still becomes a problem. It still becomes a problem. Now, if a very rich man having committed a crime and is tried before the magistrate courts, because that is the corruption element in our own legislation. Now, he employs a senior advocate. The prosecutor having to be a policeman or a junior state counsel, you already know what the outcome will be. That man will go scot-free. There's no two about it. I'm talking from experience. So, now, a litigant is free to engage counsel of his choice at any time and equally terminate such engagement at any time. It's a personal right of the litigant to engage counsel of his choice. So, this provision of the SNL rules 1979, with respect to the evidence sake and my learning brother's sake, I disagree with it. I think every litigant has the right to a lawyer of his choice. It is true that almost derived directly from the Constitution. Of course, we already know that position. So, constitutional foundation and ideal of justice. Section 6.1 and 6.2 and Section 36 of the Constitution of the Federal Republic of Nigeria stand as the bedrock of our legal discourse today. Now, the Constitutional Commission envisions a justice system that is, yes, this is what our Constitution envisages. Particularly Section 6, combined with Section 36. It is a justice system that will be blind. That will be blind. A justice system that will be blind to whether you are rich, whether you are President Tinubu, or whether you are this politician. You understand? And if you recall, this case I did against the former Minister of State for Education, let me not mention his name, so rest in peace, that had to do with stripping of 3 ladies in Warri. It went viral. 3 ladies in Warri, and 1 young man who were all staff in his hotel. There was no council that wanted to take up that matter. I can tell you, no council, all because of the personality of a former minister. Of course, the chairman here happened to be his former council. So, I said, okay, no problem, I will take it up. Actually, I lost at the High Court. I will not tell you what happened. I lost at the High Court. Expectedly. If they are talking about you, Fadali pro bono lawyers, you want to really get justice, please be prepared to lose at the High Court. You may likely win at the court of appeal on the Supreme Court, but at the High Court, it's more terrible there. So, it also includes a system where justice will be accessible, open and available to all, irrespective of socio-economic status. And timely delivery timely dispensation of cases within a reasonable time frame, provided that justice delayed is, of course, is also justice denied. And justice must also be affordable. It must also be affordable. And that is why some of us, we are keen on pro bono. I still do pro bono. A poor man cannot come to my office crying that a policeman has, it's a passion thing. So, and I think we lawyers should also be engaged in that, because we're all humans. And the reason why we are lawyers in the first place is to help the less privileged. You understand? So, but I tried to challenge a provision in the Delta State. I think that this is like Delta State where if before I get said, you file a bill application at the High Court, they will ask you to bring some stationery, drop some model deposit. I challenged it. Expectedly, I lost, but at least I tried. And I think with that, anytime I go to my juniors go there, they don't collect anything from them. They say, oh, it's from Kule, okay, no problem. Because they know I will still challenge it. You understand? So, justice must also be affordable. Regarding the chasm between this lofty constitutional idea and the practical realities expressed by the average litigant continues to widen. The reality where the system falters. Financial barriers to justice. Of course, I talk about the cost of litigation, which is actually a serious barrier. And delay as a tool of injustice. We have lawyers, and that is very unfortunate. And it amounts to professional misconduct. There are some of us here, we don't see it as part of the corruption in the system. And the system, all of us will pay for it. I have been involved in cases where everybody knows, even the courts will know, and the judge will shout, and not be able to do anything. Then a lawyer deliberately brings us every excuse just to delay the hearing of the case that we are doing. You understand? But you know what? What happened recently? In the private one I was doing, the lawyer was engaged in that. We finished that case after some years. It was now my turn. I said, and when I told him, I said, okay, I will teach you how to delay cases. Yes, because the lawyer now became the counsel to the plaintiff. I was not the counsel for the defense. I said, I will teach you how to delay cases. Like I said, I'm Mr. Chairman. After 2 years, he started apologizing. I said, look, it is not mine. I don't delay cases. But now, you have seen how painful it is. When you deliberately come to us, taking adjournments where it's not necessary, you find processes out of time deliberately. It doesn't speak well for you as a lawyer. It doesn't. Because every court, every judge will have a mindset about who this lawyer is. So it's something that we need to eschew and stop. Abuse of court processes. Our courts have consistently condemned the cynical deployment of legal procedures to obstruct justice. The use of frivolous applications, vexatious interlocutory appeals. And there are some lawyers that will beat their chest, don't worry, nothing will happen, and file this motion. It will delay the case for crying out loud. You are undoing yourself. And I'm not going to say it, Mr. Chairman. That will account for the reason why some of us are making that account for why some lawyers are poor. When your cases are moving, you actually impoverish yourself. Because you finish your case early enough. Look, even if you lose, righteously lose, you don't know, your client may refer some other brief to you. And you delay the prosecution the case. But when you delay the case because of 1 naira, 2 naira appearance fees, the client will get to and say, wait, see, you know the time, every time they pay, we start talking to you, shorting me. So it doesn't help us, it doesn't help the client, it doesn't help the courts. Because we've abandoned the courts. Filing interlocutory appeal and applying for stay of proceedings in fundamental rights, the use of course proceedings and other directive tactics to stop proceedings. Such practices undermine the integrity of the judicial system, pervert the cause of justice. I will make reference to a case that I was involved in. I think that was 2008 at the Supreme Court. My Lord Cecil Weze, DSC, may so rest in bracket case, gave a fitting description of lawyers who misuse their knowledge of the law to frustrate the cause of justice. It is in the case of EDC against Echo Nigeria Limited and others, citation supplied. Where my Lord Weze said, please, kindly listen. My Lord, pray, permit me to adopt the apposite observation of the erudite Abiy JCA, not GSA, who in Saliu against Ghana and others, citation supplied, stated that lawyers who misuse their knowledge of the law and legal procedure to stultify the process of administration of justice are a disappointment and constitute a block to the progress of the legal profession. I would not want to say anything more than that, I think. Now, disobedience of orders of courts and judgment of courts. Section 287, 1, 2, and 12, has explicitly provided that decisions of the Supreme Court of Appeal and that of the High Courts shall be enforced in any part of the country. So that is right. I'm not going to say here that government and public officials are notorious in disobeying orders of courts. In fact, nowadays it's very difficult. It's one thing to go to court, you file your action, you spend several years in the court. After you have judgment in your favor, you now spend another probably 6-7 years at the appellate. It is very, very complicated. And who's the cause of all this? I want to say it really, yes, sir, respectfully. It's not the clients, it's we the lawyers. We are the ones advising them. I've gotten a monetary judgment, and that is why some Lagos lawyers, at least some lawyers, they are very good at it. They will settle, they move on, they make millions, they move on. But I don't know about video, let's not talk much about video. And I know my friends in worry. They will fight you to finish. I think to say it is a civil war, like you are dying, you don't know what are you fighting about. Let us discuss. I've had a judgment. I can talk to my clients to give some kind of discount. Please, thank you. Let's discuss so that if we settle, why not? You can be compensated. And there was a case that I did in 2020. And that was how we settled it. I was the defense counsel. No, I was the defense counsel. But the defendant, Sheffield United Company, it was about 2.1 million there. And we closed the account. I just had to settle. The defendant eventually paid my fees. And it was a good fee. So I think we can do that. So that the legal profession will be better for it. Now, stemming decisis. Section 287, 223 as stated, of course, which is the foundation for judicial precedents. My Lord Ologe, former GSCJ, added to say about the nature of judicial precedent. No need to say that we already understand what judicial precedent stemming decisis entails. But the question is that the Supreme Court itself does not even follow its own stare decisions, its own decisions in some cases. When the last panel was on, I was discussing with my leaders there. I said, on the issue of internal democracy, of internal matters affecting political parties, you all are aware of the present position of the Supreme Court. But tomorrow it will change. Now, we don't know whether, we don't know what is internal matters affecting political parties. We don't know The way the Supreme Court will go will depend on who the parties are, or how influential the parties are. Do we say that? I know me, I've not just to appeal for the Supreme Court. You understand? When the public interest matter, the Supreme Court actually knocked me out. He said, Mr. Kunle, please, we cannot expand the frontiers of public litigation. I said, my lord, this is the Supreme Court decided in the case of oil pollution, case against Center for Oil Pollution against NPC. They said that, and again they said, and expanded the frontiers. If the generality of the people are affected, anybody can come up and challenge that matter or any issue that affects them. And I was actually challenging the anti-kidnapping of Delta states, some provisions. We stated that if any kidnapper is arrested within a community, the leaders of that community can lie. I said, if they don't like me, they don't like Legacy Kemosia, because he's always doing the electoral petition for the other group. Then they can't frame him. I said, to God, if I don't know how to find amicus brief in that matter, and then the DC said no. So Supreme Court can say it's done today, and tomorrow go back to it. So, sir, what truly pays the price? The cost of justice for sale is not borne by a single entity. It is a multi-layered body that impacts individuals, institutions, and the very fabric of the nation. We are all victims when justice is delayed, compromised, misappropriated, or sold. The judiciary itself also ends up as a victim. The first one is the poor litigants. Is denied access to justice. The legal profession, when justice is perceived as purchasable, the legal profession itself suffers an irreparable blow. Lawyers face immense pressure, both internally and externally, to compromise their ethical principles, and that's very unfortunate. It's actually on the increase. Public trust in the bar declines, and that is what we are saying. The profession is declining. People will prefer, litigants prefer to go and meet the area boys, the area touts, the warlords, to get instant justice rather than coming to meet lawyers. Because we frustrate proceedings in court, we do things that are unethical. The judiciary, the perception of corruption, even if not always rooted in verifiable fact, erodes the legitimacy and moral authority of the judiciary. Judgment becomes suspect, yes. Every judgment becomes suspect, even if the judgment on the face of the law is right. The other party will be suspected and have reached the courts. Judgment becomes suspect. Compliance with court orders declines, and the judiciary role as the impartial arbiter of this will be severely weakened. A charity that loses public confidence cannot effectively administer justice. And we all know the popular refrain, go to court. Nothing will happen. The state and democracy also suffer. The ultimate casualty of justice for sale is the Nigerian state and its democratic foundations. When the rule of law deteriorates, investors lose confidence, and that is the truth. No investor will come to Nigeria. Because let me tell you what, all the embassies, they send information back to their homes. A good investor will come to bring him in to go to the embassy, but they will seek for this information. When a case average spends on average 5, 6, 7 years in at the trial court, who will bring money here? When, even if you win, the probability that they will go on appeal is like almost 95%. And when even if you think about the court of appeal, the judge that will say, okay, this case I will frustrate it further. I know when it goes to the Supreme Court, judge, you are just going to beg the judgment get to. Because you won't get it at the Supreme Court. For at least if you are 10 years, 15 years, probably get a date. That is if you go and start looking for dates. Is that the kind of justice system that you want an investor to come and invest in? Certainly, I don't think so. So, investment is confident, leading to economic stagnation of citizens. Look at those stagnation. Citizen distribution by a system that offers no genuine recourse may result to self-help, vigilantism, and violence, plunging society into chaos and instability. A nation where justice is a commodity is a nation teetering on the brink. We are used to the popular refrain, like I just said earlier, go to court, which actually is another way of saying that you will not get justice. Now, despite these challenges, there are already signs we must admit of increasing judicial assertiveness and intolerance for abuse and corruption. Our courts are constantly enforced. Now, let me give some practical examples of some of this. Yet, amid the challenges, there are encouraging signs. I have observed an increasing acceptance from the bench, a greater willingness to impose sanctions for frivolous applications and abuse of process. Honestly, we're talking about the 10 million naira. Actually, I don't agree with that. But I think that's one of the ways that the courts now want to assert the authority and prevent the abuse of judicial processes. But that is the wrong way of doing it. The NP already provides for how lawyers should be sanctioned, so the courts will not add that to their own responsibility. And I wish, like somebody suggested, that the latest thing, probably when doing one of your elections, election cases, probably, I know they will not sanction by the legacy, but probably you can come in as a pro bono lawyer and help us push that cost, so that, not only the next meeting, the lawyer was a cost of 50 million to pay within 90 days. Where would the lawyer get that kind of money from? So we are saying that kind of practice for regular again. So we need to do something about that. Pathways to reform, reclaiming the sanctity of justice. The task of restoring justice as a right, not a privilege, demands a multi-pronged approach involving all stakeholders. So it cannot be for the lawyers or for the courts. All of us must be involved, including the politicians. At the end of the day, we also suffer it. APC was once in opposition. What they were shouting against, now they are in power now. It was a problem. I was talking to my NSA. I said, PDP was in power for 16 years. 16 years, they had the opportunity of effecting a lot of possible reforms in the Electoral Act. Now, everybody is shouting. Tomorrow, when this is out, they will come back and shout. So, that is a problem. So, all of us need to come together and see how we can, evolve a collective solution to all this. Now, what some of the solutions I recommended are strengthening judicial independence and welfare. True judicial independence requires not only protection. Of course, we know what judicial independence entails and the welfare of judges. Of course, they are doing something now, we appreciate them. But in terms of judicial independence, let me state it here. The Benin Past First Vice President, in our own, part of our passion, to do the right thing at all time, even for the bar, for the bench, I think that was, Chairman, that was not 2022. Thank you. I was 2022. We decided that, except for myself, since the NDA refused to take up such matters, we filed 3 matters at various courts. One at the Federal Court of Abuja, another one Federal Court of Abeokuta, and one Delta State High Court of Asaba. With regards to autonomy for the judiciary, the Constitution has already provided for it. The judges, the judiciaries, they are not supposed to be getting their votes directly from the government. No. They are supposed to go to the House of Assembly, present their budget estimates, and defend it and get their monies. It's already set in the Constitution. So, we are there before the Federal High Court, Abuja. To cut down story short, let me not mention the name, but that judge is on, I think it's on suspension, let me not mention the name. Told me, because he was the claimant, plaintiff brother, told me, Mr. why are you worrying yourself about the welfare of judges, about judicial autonomy? Why are you worrying yourself? I think you should withdraw this case. I said, my Lord, I cannot withdraw this case because the welfare of judges is a very important expression of justice. If the judges are not doing well, it is certainly affect how they will conduct cases. The judges are able to, be reached. He said, okay, I'm advising you to withdraw this case. He said, okay, I said, my Lord, I want to think about it. It's okay, I will give you time to withdraw it. And if by next day you don't come and withdraw it, when I withdraw it, when I strike it out, I'm going to impose a punitive cost against you. We didn't appear in that case in the Supreme Court. Most likely we must have stopped. That is the people you are fighting for. Now, the one in Abeokuta, I went there personally. I had units. And my Lord was very happy. My Lord is now the Court of Appeal. Very happy. So yes, this is the kind of matters that the NDA should be involved in. So I was happy. In my amateurish manner, thinking that, judges will be in our favor. Look, don't be too happy when the judge is smiling with you, please, from experience. So, I just for judgment. My Lord called us back. A year ago, so that my Lord said we should come and argue on the issue. I've forgotten the issue. So, cut the long story short, the case was not even dismissed from house. That's the judiciary you want to help. Now, Delta State was a completely different case. The AG the Attorney General's office was represented by a director of the ministry. Incidentally, the person is like judge on the data side court, and he did not oppose. All the release we sought were granted with respect to financial autonomy for the sharing in Delta State. But let me pause for a moment. They refused, the same judiciary refused to comply with it. They are still, so they are very happy going to the executive, to the bed. They are very happy, and that is a problem. So, technology and transparency, expansion of e-filing, electronic case management system, and public access to court proceedings can significantly reduce human discretion, improve efficiency. Yes, that's. And ethical reorientation of the bank. The Nigerian Bar Section must rigorously enforce the professional conduct rules, that is the RPC. Continuous ethical training. We have said much about this. We will come back tomorrow and still talk about ethics. And everything we see in court, our lawyers violate the rules of professional conduct. And unfortunately, the judges, they just turn a blind eye to it. At the end of the day, it will still come back to us. The legal say, this one, if the legal uses it today, tomorrow you go and tell another person that you black lawyer and a lawyer, I can pay anything to do anything for me. That is bad. Because once they put a dark stain on you, it robs from all of us. It affects all of us. So please, our ethical, we need to do some ethical evaluation and orientation. Please, very important. I was finding. Enhance access to justice, sanctions and accountability. The agency needs to sit up. The agency needs to sit up. And I can tell you for free, the agency is not doing much, not doing well, and the agency needs to sit up. You can write petitions to the agency, pray. If the person writing petition against is not some person of much influence, pray that it will be successful, or that they will respond to you. Agency needs to sit up. Agency also needs to sit up. It is the special role of the indispensable role of the NBA. Of course, we have said much about that. Conclusion: a call to action for just and ethical tomorrow. Justice in its purest form must never be a commodity to be bought and sold. The consequences of allied justice to be traded are dire and far-reaching. The poor pay with their sufferings, their rights continue to be trampled underfoot. The legal profession pays with its integrity, its noble calling tarnished. The judiciary pays with its legitimacy, its authority questioned. The nation pays with its stability, its democratic foundation eroded. Things fall apart at the center can no longer hold. Of course, anarchy now rules over everything. A society where justice is forsake is a society on the brink of collapse, where the social contract is broken and chaos rules. The task before us, therefore, is not merely a professional obligation, but a patriotic duty to restore justice as an inalienable right for every Nigerian, not a privilege reserved for a select few. Closing remark. Let this topic. Okay, I thank everybody, I thank the legislature, I thank colleagues, I thank the chairman. But let me close out with the statement of Christopher Chakoramide, the first lawyer that was called to the Nigerian bar. I think it's not 70-something, I've forgotten the particular year. But he had this to say with respect to the noble calling of lawyers. He said, lawyers, we live for the cause of the society. We live for the cause of the society and for the direction of humanity. Let us take this home and ensure that we do our bit to continue to ensure that justice remains inalienable to all Nigerians, and that so that the profession will continue to be respected by all as one. Thank you very much for this.
Thank you so much, Oledo, Senior Advocate of Nigeria, for that well-delivered paper. I can see the eyes of some of my friends here that are urging me to listen faster. So we move faster. Now, we have three discussions. I have observed in recent times that discussants come to the section holding their own papers. That is not the way I think it should be. They are discussing to discuss the paper delivered, either agree, disagree, or add other issues that this speaker didn't say. I think that's what we should do here. And each speaker, each discussant will have 10 minutes as given to me by the organizers. We have 10 minutes. But since I'm the chairman, I have the overall authority on so many things, so I have to exercise some. Now, who really pays the price? I will pick up one at this stage. The lawyers do pay a lot of price. Now, let me say something. I read a story told by the Honorable Justice Okoja late, who said when he started practicing in Aba, he observed that when he was coming, if it was on this side of the road, nobody would be on the opposite side. As far as they sight him, they move to the other side. So when he really observed that was what was happening, he called his family. He said, is there a problem? Why is it that when I'm coming along the road, people tend to move to the other side of the road? They say, you are a lawyer. Who dares come close to a lawyer? But today, if you tell somebody you are a lawyer, they will beat you up. That is a loss. If you don't know now, we lost our integrity, our aura, our respect arising from justice for sin. May I now I want to call on Professor Ezegwa to be the last, because the other two panelists are not lawyers. So you come in last, the lawyer first, the lawyer last one in the job. So may I call on Prof to give us the historical background of the perspective. Thank you.
The chairman of this session, very distinguished members of this audience here present, I want to start on the note that the chairman has already intimidated me from two perspectives. The first, he saw me carrying papers, so he wondered I'm not to deliver another lecture. Number two, he said we are two who are not lawyers, and so we also have to take that into account. But I want to put it to the chairman that having married a lawyer, who is not just a lawyer, but a professor of law, that what God has done together, let no chairman divide. And so, my great members of this audience, as introduced earlier on, I'm Professor Eddie Iragwe, and I've been involved with the University of Benin now for more than 50 years. And so one of the great privileges we enjoy is when we come to gatherings like this, we come across so many of our former students, colleagues and all, who are now doing very well in different spheres of life. And I've also been privileged to be highly involved with the Bar Association, both at the national level and here in Edo State. So I thank you really for the privilege again to be called upon as one of the non-lawyers, non-certified, to still address the eminent lawyers here present and judges as well. And to testify to that, and that is why I carried one of my papers here, which I printed out just before I came this morning, is that I was privileged to be the keynote speaker in the 2017 Annual Law Week, which was organized by the Nigeria Bar Association here in Benin. And it was held on Monday, 8th May 2017. Incidentally, why I decided to bring the paper out is that the topic that we addressed that day, which maybe many have forgotten now, I will remind you of it again. the topic and paper I wrote was corruption in the judiciary. And then the disciplinary role of the National Judicial Council vis-a-vis the law enforcement agencies. There are many other papers I've been privileged to present when called upon by the MBA here in Benin. Obviously, the topic of today is just a continuation of that discourse. That is to the extent that we are so worried about what is going on in the judiciary. The one I had to address then was dealing with the judges, what should be done concerning them. But our lead speaker here today has really further expanded the horizon of the discussion by highlighting the role that even non-judges, other players in the judiciary, are playing in it. And by extension, we talk of we the people, the role that we have been playing as far as the corruption in the system is concerned. My major submission here is that I am a lecturer, and one of the fundamental responsibilities the society has entrusted to us over the years has been to mold characters, educate persons that will now run the society. And that is why when it comes to the conferment of degrees, which was done for the lawyers here present who went to the University of Benin, you will recall that by the time the dean read out your names and all, the pro-chancellor or the chairman presiding that day stood up to say, we now admit you into this degree because you have been found worthy in character and in learning. And just before I left school this morning, I had a final year class, and we were discussing how the OAU was trying to talk about arbitration, conciliation, and things of that nature. And I just veered off to talk about integrity, to talk about what the society expects from us. But you know, one of the darkening spirits I'm always facing when I come to a forum like this, and there is a clear testament to it today, is that, come on, Eddie, you guys are wasting your time. Because the society that you are trying to build, that you are trying to reform, that you are trying to mold character for, the society is in a total kind of collapse. In this paper, there is a section where I clearly pointed out that one of the greatest challenges we are facing as a people is that those that have been entrusted with power, with resources, with leadership to preside over the affairs of our nation, our lives, they are almost all compromised. And so it becomes a case, who are you talking to? Where, for example, corruption seems to be evading and almost pervasive everywhere. At the end of the day, my major submission is that we are all suffering because of the sale of our. It is in terms of the embezzlement, misappropriation, and condoning of the very, very visible corruption we have in our system. So whether we like it or not, the kidnappers are there, the bandits are there, the security system is collapsing, the infrastructural system in our country is virtually almost zero. We grew up here, when you talk of historian, as a little boy in Auchi, how we used to go to public taps to fetch water. It is not something that will never happen again. Not because the society has provided it like in the UK, where water keeps on flowing always. Because you must have your own borehole. The government is coming to tax the borehole that you are executing for yourself. Are we making progress as a nation? And so the message is, as has been clearly stated by all, I want to always my message. I'm standing here, I've lectured in University of Benin since 1982. I've had students, even law students have interacted with us. Almost all the graduates for a long time, I was teaching general studies to all. Take Nigerian peoples and culture, this is one of the authors. But I can stand on matters of integrity and say anything that you say that you always hear. Lecturers compromise, they are asking for what you call pay money, sex and all. With some of us can still stand by way of integrity and say that this is the right thing to be done. So my challenge is, my message is that we are almost all paying the price. The corruption in the system, whether in the judiciary, whether in administration, whether in the system, educational institutions, in the health centers, where people go, sometimes you cannot be seen because you don't have money to pay and all of that. We are now calling on us, whenever we are opportune to be in charge, let us make a difference. And that can make it that there can still be judges that can stand fair, and people will say, if you go to this court, you will get fair judgment. And so, I want to congratulate again the FBA for putting together this and for giving me the opportunity to say this. So just finish, Mr. Chairman, here about the issue of corruption. I think this is it here. We want to observe that the judiciary occupies a very pivotal role in the American-style democracy, which is invoked in Nigeria today. That is the presidential system of government, with the attendant principle of separation of powers. Separation of powers, which is between the executive, the judiciary, the legislature. And we want to add that it is partly because the judiciary has compromised by way of succumbing to the executive that, and even sometimes the legislature, that our democracy is failing today. As everybody has almost been saying, when you are not satisfied, it's legal to court. But then, we now know what happens in it. But I want to end on a final note. When I talk to my students, I say, don't give up hope on Nigeria. I'm speaking from history. And the reason I'm saying it, I'm not the one that is likely going to be the one that will bring the change. But it's that persons can emerge that will say no to what is going on in Nigeria. Check Ghana, ask for running. Someone like that can emerge in this account. We must still believe that Nigeria can have, because, let me put it here, governance in some states, I use this as the oasis of hope. Some governors have emerged in their states and they have changed the narrative of their states. It is that thing that can still happen at the national level. And Nigeria can make it. Thank you very much for the opportunity.
Thank you, Amiable Prof, for your contribution and intervention to this topic. May I now call on Reverend Lolo to give us his perspective on this issue. I've heard so much about you. This is the first time I've seen you live. It's my privilege. You are welcome.
Okay, I want to again thank the MPA for inviting me, and let me also stand on the existing protocol. I will just give you two stories. That will give my presentation, but I want to start with for over 20-30 years now, I've been working on corruption issues around the world. I became the co-chair of one of the biggest coalitions in the world, called UNCA Coalition. But my impressions for working on this sector for over 30 years is that corruption is not being used as a weapon to disempower the poor. So when you hear government fighting corruption, it's actually to disempower the poor. And even so, and I will categorize it like this: in the universities administrator, they are not set. Then the professionals, they are their enablers. And so when we come to conferences like this, we point fingers. But the problem is with us. And I'm happy when the MBA invited me, I was asking myself, would they like to say this? Will it be appropriate? When the problem we have in the country today, the professionals, the lawyers, the accountants, they are the major problems. I'm sure you know about the Ozekume, a son. Hello? I don't take myself away from this categorization. We are all involved. And because my Christian faith tells me that when you confess your sin, God forgives you. Until we all confess our sin, this hypocrisy will continue. If somebody of a segment, a son, a respectable, is this thing you call it, I'm not the learned man, who's supposed to be the face of the legal profession in this country, could he and his son forge a passport for property deeds? What are we saying? You know, when the lead presenter was presenting, I see him as just one man fight. And I see him struggling. That's the challenge we face today. So, and technically speaking, the criminals, the kidnappers, those who are involved in kidnapping, that's their own way of fighting back in society. And they live in the same society with us. Just like when you wake up in the morning, you pray that God bless me, bless my family. And you do this by, as a lawyer, you are involved in a legal framework that undermines society. What happens? The kidnappers also pray in the morning, God, make it possible for me to kidnap. Just like the man that built the casket, he prays, let my business grow, and that means people should die. And so nobody wants to hear the truth. And this is the reality we face in society. So until the professionals, enablers, cleanse themselves, we have no authority to begin to point finger. And if you look at the paper, we are all victims, both the rich and the poor. Now look at Sam. So when brainless become the top of a country, what happens to such a country? When incompetent lawyers become Sam, what happens to such country? So this is the challenge we face. Until the legal system is sanitized and they stop becoming a professional enabler for corruption, we don't have any morality to point finger. The politicians, I can tell you, no politician steal money without professional enablers. The auditor, the accountants, the lawyers must be responsible. Most of the lawyers, they don't pay tax. there's no way forward. The problem why there's no way forward on this, the elite of the country are involved. And because the elite of the countries are involved, just NBA election will come here, the next thing you'll be speaking Parako, you have destroyed it. You want to go to NUJ, a professional journalist group, you start speaking Benin, you have destroyed it. I was born in Edo State. I run the most successful NGO in Edo State. I don't need anybody to influence me. I get my funding, I'm well funded, I'm independent. But when it comes, do you know, I employ Edo people. I have over 20 workers in my NGO. I pay my tax, but my wife cannot work in Edo State. My children have no hope in Edo State. What a country is that? No, which country is that? And if I apply for a job, the next thing you will see, oh, we will go. Oh, yeah, so, and who is doing this? Professionals. So, is it we're in a system? So, I want to appeal the challenge. If NBA will say in the next election that is coming, and Obama can contest the election and win, that will way forward. But if Obama cannot become a chairman there, we have no right to point finger. And if NBA cannot say that a son with his son using documents, fake documents. And up to today, NBA has not been able to come out of the mess. What are we saying? What are we saying? Thank you, God bless you.
Thank you, Reverend Golo, for your perspective to this issue, widening the scope to include so many other things, other aspects we're not looking at. Well, on the issue of Chief Executive Senior Advocate of Nigeria and son, the matter is solving this. So we wait and let hear what the court will say. I am very sure if it's executed, the bar will be happy. If it's found guilty, we will get his punishment. That is really the case. Can I now call up Professor Lemia? 10 minutes, please. 10 minutes, okay. Now look at me harassed.
The chairman of the section, my very respected senior advocate, distinguished colleagues, the topic is justice for sin. Who pays the price? The lead speaker, my learned senior advocate, dwelt so much on the definitions and also told us the possible remedies. But I'm here to talk to you, not about that because I need a paper and that paper is there, but that is not what we're discussing. When there is a commodity for sale, there are purchasers, there are those who buy it. Is it not? We have been overly rhetoric. We don't be talking grammar. Without specific issues. Injustice for sale, who benefits? Who are those benefiting from justice? This is one area I just want to talk on briefly, so that we can go home with something very tangible. The best set of people who are able to buy justice are those wealthy people with money. Because a poor man living at Bali or somewhere in Houston who cannot earn anything, who has no money,
my dear Professor Ragbe, my elder brother, the whole oratory was from partly from him. Talk about politicians. The corrupt politicians, not all politicians are corrupt. The corrupt politicians are those who are capable of buying justice. Because the justice is for sale. Somebody is having a commodity. But who is having this commodity? That is the next issue. Who is having these commodities for sale? One of those people having this commodity for sale is the complicit lawyer and the judge or judges. The complicit lawyer, there's a case I referred to, the paper is submitted earlier. In that case was a lawyer who went, collected money from his wealthy client to go and bribe second party. Of course, he was caught in the act, and the consequence of that, the lawyer was exposed. But how many of those type of lawyers who are never known or seen in our society today? If the judges want to sell, somebody must provide purchase for that judge. And if you don't have these lawyers who are in fact accomplices of complicit in the whole system, there is no way you can have the same or commodified justice. Then of course the judges themselves were asking, of course my laws are no longer here, but let us be honest to ourselves. How much is the salary of the judge, including what we have as monthly allowances? Let's be honest to ourselves, gentlemen. If I have a case and report, no problem, I'm ready to do that. Because the rule is that if you give judgment against us here in Nigeria, we can go to the court of appeal. If the court of appeal is not helping, we go to the Supreme Court. And if the Supreme Court is not helping, we give it to God himself. This is what we are talking about. A judge earns money. The judge is having a house in Abuja. He has money in Port Harcourt. The children are in the best school, still on that bigger salary. And you are asking for those who said justice. My dear senior, I use it as genuinely asking. We're all the examples of our faith. These are the true nature. Of course, we have done so much. I want to, let me refer to the little things I wrote down. I said in my work, when we are talking about justice, I did one work long time ago. The man sitting there, the senior advocate, was the man who recommended me as a young lawyer to the academics. His reference letter speaks volume. So, when I was writing my PhD thesis, I did this work, restructuring the administration of justice, the judiciary in perspective. And this is what I have to say. I said the importance of justice in any human society cannot be overemphasized. This is why justice is like to share with natural law and institutional immortality, which present a constant paradox. I also said it is so ancient that everything has been said about it. And so more than that it constitutes a continuous and inescapable problem in ever-changing context of contemporary society. If you look at justice in the abstract sense, it is nebulous. But when you apply to individuals like you and I, you know it's a thing you can see, felt. It takes that down. Because when there is justice in the matter, nobody tells you. There was a matter long time ago, we don't want to make any reference. I had a matter, and my client told me that this is what he said is setting order. Then I was stronger, then I was younger, I was bold, fearless. And I went to him, this is what we are here to learn. These people are doing that. He said, did you believe that? It's not that I believe you, but this is what he said. At the end, we went ahead, and that judgment we anticipated came out. Are you getting it? This is the man who says justice. So that is exactly the situation. But we have a hope. The hope has been analyzed by Professor Oteto. You and I will have a way to play. How are we going to do this? First,
let us ensure that whatever we are doing, we do it with integrity. Osayamabo spoke of the electoral reform, but throughout his speech, he was talking about what is happening, the topic we are discussing now. You were here. He told us a story of how a certain lawyer I once had in the back told you that your judgment is at urban market, and people are already having the dating just to run, just to wait for your judgment. These are things. How many of us are bold enough when you have some issues to say, my Lord, from the past available to me, this is what we have. It's not that I believe, but I want this matter. One of such men who do things like that, where is he? Backup. He doesn't wait second. If he hears at all, he fires himself. So if all of us can behave in this manner, what else do you want us to do? Physicians, he thyself. That's my last one. Thank you.
Thank you very much. Very engaging one and that. Please, we'll put our hands together again for the chairman and panelists. A great one. We have the gracious leave of Mr. Chairman to interject and do this announcement because it's important. Before we interrogate the topic, we want to announce, hello, we want to announce that you remain seated after the interrogation of the topic, after you may have finished asking all the questions. Please check your bag, make sure you bring out your meal ticket. Nobody will be served standing. Everybody will be seated wherever you are. Handy with your meal ticket as certification to the plate of food. So please get your meal ticket ready and be seated where you are. Anyone standing will not be served, so we can have orderly service. In addition, we appeal that everybody, while you remain seated, our Leonard Silk, our guests, and the ESCO, your arrangement for late lunch, is upstairs. There are people around to check on everyone there. The Leonard Silk, senior lawyers, and the ESCO. There is an arrangement for that. To welcome Ego Edeki, Esquire, senior lawyer. Be welcome, sir. Chief Edo Sani, Chairman Emeritus, we appreciate you. And all other senior colleagues and respected colleagues. Thank you very much. Mr. Chairman, interrogation of the topic.
Thank you, Master. Now it's question time. We are going to have 4 questions. 2 questions from this end and 2 questions from this end. And I'm going to give priority to women. Let me just put you on notice. Now, can we have questions? Well, Dennis has said no women at the bar. There's one Honorable Justice is now named of Lagos High Court in those days in the early 90s. He said, if there are no women in the bar, let's go to the intro. You know what Yes, now permit me to stand up so I will do this quickly. Questions from this side, please. Yes, your question. Please, you are not asked to give an opinion, you are asked to ask questions.
Mr. Chairman, sir, my name is Jonathan Aidewa. Chairman, sir, I'm quite disillusioned because it appears that there is no hope. Judging from my brother, when I saw God lately, if I didn't know you were here, I would have begged you that this is NBA. Let me do as possible. But you were still able to. Now, we have even institutional problem. For example, the police, you go to report a corruption case to police. Is the FCC that is here? This one. See, I see this. Which institution that is corrupt? The last hope is the one that is corrupt now. Judiciary. That's the last hope. Or supposedly the last hope. The church is corrupt. Everywhere. So now my question is, you have all atomized the decadence, the corrupt nature of our country, this entity called Nigeria. What is the way forward? Practical way forward. Now, please, I want answers, not theories. Practical way forward. Thank you very much.
Thank you. Second question, please. Still on this side. I hope Fida will not cry for marginalization. On this side, can we have from this side, please? Yes, the woman. We were jumping up when there was a lot of.
Yes. Good afternoon and opportunity to you. Before this law week, okay, my name is Roland Odukuogo. Now, before this law week, I've been asking some questions. I've been asking some seniors some questions. And there's this particular question that is bothering me. And the question is, between the politicians and the lawyers, who are the main problem in this country? Thank you.
Thank you so much. Yes, this is the mic to your right is assured. Please give it to that lady. Yes, thank you.
The chairman of the session, good afternoon to everyone present. I want to stand on the already and what we have heard thus far is so disheartening. Okay, my name is Stella. What we have heard thus far is so disheartening. And for all that are coming up with the activities, is there hope? I remember what happened yesterday. We were coming downstairs when one of the senior colleagues was in front of me. He said, the situation where we find ourselves today, if you don't struggle, nothing for you. And that thought crossed my mind. As a matter of fact, it is true. These days, if you, maybe by way of conduct or anything, you want to talk about integrity, they will tell you, they see you as a deviant when you talk about integrity. So many things are happening that when you speak up, there's a way they shut you down. So the question now is that we are asking ourselves, because sometimes we look at our children coming up, is there still hope? What do we do? That is the big question. It's almost a rhetorical question as far as I'm concerned, but I still ask once again, is there still hope?
We have only 4 questions. We already have 3 persons who have asked, so the remaining 1. Look behind you. Just look behind you. Somebody is holding up his hand. So take. Yes. I think we have the shot. Mr. Chairman, I had an experience. My name is Mogi Lawani. I had an experience the day the judgment was delivered in the case of Tinubu election tribunal matter. There is a place I drive where when I'm driving home. My friends are there. Whenever I come there, barrister, we just laugh together. Now after the judgment, I was driving home and I said, let me buy food. The moment I entered that police station, I knew there was trouble. So they wanted to mob me. I drove away from that station and ran away. See, lawyer, that I've been put up on this country, not going again.
a lawyer, I wish this safe in this country. In the practice of protection, the men who killed my friend that day turned to be my enemies. They almost smashed my windscreen. I had to drive the road with speed because they saw me as a problem. Now when I give up and say, oh, we know we're election. Sir, I wish to say in Nigeria to practice law. Thank you, sir.
Thank you. That answers this. We now give it to Oderesi for his own question, comment, perspective, overview. Welcome, sir.
It's not really all doom and gloom. If we were to demonize you for collecting money from people abroad, I'm sure that would maybe be unfair to some of you. Just like the way you say sit down for this day for the no. The truth is, we all have roles to play in this matter. If you talk about the buyer and seller, if no judge gives the rule, no lawyer gives, we will all do things correctly. But you see, we want to take the shortcut. Everybody wants to get an unfair advantage over the opponent. And we all keep grumbling. It's not going to work. And some of our colleagues, the market, some of us, peddling the same story. They will tell you, this one no road, this one no road. These are realities. But you will not change who you are because you want to get temporary advantage. And that is why I commend you for the effort you put into your paper. Unfortunately, you say John intimidated you into talking to your paper rather than delivering it, but I think you still managed to do justice to it. So I want to thank you, John, for the way you handled it. My advice to all of us is this: I have cause to go to a judge. I was instrumental to be appointed, and I got to know that he had past business. I went to him with a couple of our friends, and I said, money that is delivered at night is gathered in the daytime. So don't take the cloak of darkness covers it. And I said, so I hear you collect money. He denied it, and I told him in that particular case, he had just been paid $5 million for a matter. And I told him, and he thought that it was true. And I asked him that to do the appropriate thing.
So,
thank you, Mr. Chairman. Yes, it is way forward. Some of the ways were itemized, practical ways were itemized by the lead presenter. You see, when we have serious, more stringent measures by NJC against erring judges, this can serve as one panacea to preventing them from selling. Because without a seller, you don't think of a buyer. If we do that, then of course the second one I want to say, he's also talked about it practically. He said there are so many things we need to do. As senior advocate had just told us, we all are in the same boat. Let us exhibit our integrity at all times. Once you do that, has any person ever accused certain lawyers in Benin here? All of us who practice here, we go to the high court, from high court, court of appeal to everyone. There are some lawyers, when you still mention their name, people still bow their heads. But when you talk about some other, turn away, they won't say anything, they turn away their eyes. So why can't all of us emulate that one when you mention the name and everybody? Bow his head over head. That is then the last one for lawyers. We have said, do the right thing, and you'll be safe at all times. No matter what people feel, they will still distinguish you from others. Thank you, Mr. Chairman.
Thank you, very distinguished guests. In the prompting of my presentation, I failed to specially talk of my privileged family relationship with our very learned seal, known Mr. Moses King, whom I've known for close to 40 years as a family, when he was just starting and I think we were still riding a Volkswagen then. Just that you are writing bigger cars now, my own is still 504 or something like that, because I need to be a lecturer. So, sir, it's always a pleasure being with you. My great members of the audience, I actually captured it, and the letter seal referred to it just now. We should not go by the cliche, if you cannot be there, join them. You can also still stand out. Because being a historian, I've been conscious of that. Being a public figure in quotes. Because for many in this city, if you ever listen to ITV, you come to public gatherings like this, EBS, channels and all, you will see a day writing. I have integrity to protect. Just like when you were asking, is it possible for lawyers to still practice? It's almost the same question that we ask about lecturers. Who impression is created, they are looking for guests to seduce, they are selling handouts, all of that. I give an instance. There was a protest sometime ago in Ekosoli, that is the University of Benin, and they locked the gate of Ekosoli. Then I was staying in Ekosoli as a young lecturer. The security men were all at the gate with guns and all. And then I said I was going in because my family was inside the village. I was going to enter the village. They went to tell the commander. They said, see this one. He said, one enter. I said, yes, I'm going in. Because I have nothing that the students can hold against me. And true to that, I crossed the gate, and when I entered the Ekosoli, who be that? Who be that? They said, Dr. Eragu. Now our person. They came around me. And I said, what is the problem? You are protesting because they disqualified a candidate at that time. And I eventually considered, I moved to my house because I had a clear conscience. When I became dean of students of that university, they called me the unbiased dean. That was because all elections we conducted, everything we did it with transparency. It is that I had marked, I came back from the UK about 3 weeks ago. They took my exam. I marked over 260 streets. I don't know the students by name. Those that have scored A's have scored their A's. Those that have scored B's have B's. Those that have failed I can assist. So what we are saying is let us not
thank our son. We shouldn't use a general statement. I think that's using one color to color everybody is unacceptable. So I defer to you on that. And exactly what has just happened, you know, when my friend raised the question whether there is hope, by what Hassan had just said and what Professor they have said now, is hope, that there is hope. I think the true pathway is that in your own little small way, start something. I was ordained in your apostolic church more than 25 years ago. And when the white men first introduced New Apostolic Church to Nigeria, it will interest you to know that the district I am hasn't worked out very well. So I decided to create alternative. And New Apostolic Church is not owned by individual. It is worldwide. Today, my congregation is one of the best in the entire district. As I said, if you run an NGO, you can only steal money for 1 year and 2 years. But you can't run an NGO for 30 years and say the donors are safe from me. It's not possible. And so I completely agree that these pillars of integrity can be added together to create a model that will challenge this hopelessness. So I would say there is hope. So MBA should identify those chemosias and the proceedings and continue to encourage them. And I hope before Muslim will leave this world, even in its chamber, there will be Mosia's children who will adopt this philosophy, and that they can go to grow the system. Thank you.
I You have 3 minutes to round up.
Thank you very much, Mr. Chairman. Once again, I refer to the evidence sake. We have a very serious problem. Doctor, I can feel you when you deliver your intervention. I can feel you. It's a very, very serious problem. Corruption has so much deep into the family everywhere. I have a mentor in the human rights field, very fond of SAM. We shout almost every now and then. At times I complain to him. I'm actually getting tired. You know, because fighting impunity is not that easy. I'm telling you. They will fight you back. Myself and my chairman, we know that we have missed some opportunities, cases that we ought to have given, but because of our principled stand. But you know what I have noticed? My God, all these years that I continue staying being principled, I was actually getting better. I was getting better. I'm not a poor lawyer, but my friends, many of my friends that I see misbehaving, I'm far better than them. Because of what? Integrity. That's it. Thank you, sir, for bringing memories back to me. Do you know what I feel when a client calls me and says, Mr. Kunle, somebody recommended you. They said because nobody will feel shaky. You don't agree for anything if you're not rich. I'm always happy when the clients make such a statement about me. That is the best testimonial anybody can get. Integrity. Even if that client does not eventually maintain you because of fees or whatever, but you'll be happy that this is the testimony people have about you. And let's say, you being our mentor, we take it after you. I am proud to say I have that integrity. I know I cannot have that integrity. That is why some of us when we talk, people listen to us. And when we find some cases, they say, they will come again. People will not be running letters better. So please, integrity matters. That is what can take all of us to take Nigeria to wherever we want to go. But please, we know the judiciary is the last hope of the common man. Unfortunately, it's becoming the lost hope. But we can always make it better. And it's only we that can make it better. Please.
Thank you so much. Ladies and gentlemen, thank you for your time. But I want to take my time now. Yeah, but this issue is a very serious issue. I'll take just very much of your time, very small time, but it's very important. And the people I'm speaking to are going to be younger lawyers, not the older ones. Or you don't know how, you cannot learn how to use your left hand in old age. So I already moved. For those of us who are already bad, we are bad. But for the young ones, I like to leave the message of hope or something to chew about. Now, when you talk of justice for sin, only one person in the system can say justice, the rest are biased. And we cannot be hammering on that fact. Only the judges, only the judge, only the magistrate, only the president of the customary court has justice to say. The rest of us are biased. So if you have no commodity to sell, who will buy? Now, how do we get to have judges, magistrates, presidents of the court who have justice to sell? Appointments. We keep using this issue over and over again. The issue here is appointment of judges. One, the corruption starts from the appointment of judges as far as the judicial system is concerned. My attention was drawn to this issue sometime in 2014. A Supreme Court judge was appointed from the state. The government of that state through a party and made some statement that we now have our own Supreme Court justice. Immediately I knew that that man did not get there by marriage. He was planted there. Now, if you look at our politicians clearly, they operate like mafia. You plant a seed, you let it water. It is not for immediate reaping. So that is what our politicians are doing. They have their own judges. They ensure that they appoint their own judges. And let me tell you, one judge who is wrongly appointed may have up to 30 years on the bench. So you have a corrupt judge on the bench for 30 years. If you have about 5 of them, you have 5 corrupt judges on the bench for about 30 years. By promotion, you become CJ, you become Court of Appeal justices, you become court justices. That's the problem. They are being planted by the politicians. Corruption is not only about taking money. Corruption is influence. Can you be influenced? And I can tell you that a lot of our judges don't even take money, but they are under heavy influence because they knew from the one, or they know from the one, that they are not supposed to be there, and they were there for a purpose. So when that purpose starts calling, they obey, they must listen, and they must answer. That is the roots of the evil corruption in the judiciary. Get that one. Now, I also want to do something. There's something that I was reading this one, and I made a comment somewhere in one of the platforms. This issue of River State governorship. How can one man be the governor of 5 political parties? Even if advocate is involved in the letter writing. And I said something. I said, when that thing gets to court, so when it gets to you, you're very sure that the court will find a way to say that there's nothing wrong in being the PDP and APC at the same time. Watch it. Just watch it, what will happen at the end of the day. Those are the things we are talking about. Now, the Delta State judgment by the rest was talked about at 5. We got judgment. We didn't finish, so that I want to finish the story. I don't know what to give me. As if they realized that something has gone wrong. We were called again to say, look, that's your judgment. We want to touch it. We want to amend it. It's seeking our consent for the judgment to be amended. But I said, you have given us judgment, we fought for you. So if you want to amend the judgment to give power back to the executive, anyhow, don't call me. I'm not interested, I'm not involved. Anyhow, I won't. So today, because I don't want to see the corruption, I didn't bother to go back to look, but they are not doing that thing. That is what we fought for, spend our money to ensure that the judiciary is set. We have some financial autonomy. So what are we talking about? Now, what is the way forward? The way forward is this. Every man in your small corner, confront it. In your very small corner, confront it. Do what you can do. There's a matter I'm doing in Kano. I want to say this story. There's a matter I was doing in Kano. I'm doing in Kano presently. And people wonder, how were you brief you were doing in Kano? There was a federal high court judge who was misbehaving. It was a winding up proceedings of the court. He was doing everything by ex parte. They will come to court today, he will take decision for the next day, and ex parte order has been given between the days. And that was how we asked for compliance. When you want to move the motion to amplify, he will not accept. Then when there's an adjournment again, something has happened between walking to Western Council. And there was no one I can't know who was trying to confront the judge. So somebody called me, hey, can you go to Kano? Can you do this case? I said, I preach with that, I pay. And I went to Kano, and I arrived in the Federal High Court to Kano. And truly, we are verified by the guy was the mother has verified the preliminary objection. So my Lord, we have a preliminary objection. We said, no, wait, cancel for the applicant. Have you compared with the last order given for publication? That order was given in between the last 2 adjournments. So even when I was talking about, we had the motion said no, classify your notice of compliance and everything, and adjourn again. Of course, in between the other, I took my action. I told my clients this is the way, the best way is we write to the agency, we petition him. So we petition to the agency. Then I wrote, I filed a motion for you to refuse it, attaching the motion the petition to the agency. So when we came the second time, called the matter, I wrote down, I told him, my Lord, I have a motion. I'm very sure I've read the motion. He said, yes. Do I have to move it? Or do I have to tell the court? He said, no, I'll transfer the case. But I didn't want people to hear, so we transferred the case. The job died 2 weeks ago. I said, oh, it's making noise. It's a corrupt judge. Simple. SAP corrupt. The worst aspect of that, they have done something like that in another case that went on appeal.
And there's a judgment important case of that same fact, lambasting him, yet he was still doing the same thing over and over again. So we must have the courage, that's what I'm telling like a young man, we must have the courage to confront evil. But it is not easy to say that the lawyer is easy for one lawyer to face something. It's not easy. We must have grown to a very large extent. So the ball is in the court of the branch. When matters like this come up, what happens at the branch meetings? What happens at the branch level? Most branches, they dodge the issue. But the branches are set up to fight collectively. That's what I'm telling you, Benin branch. Can you tell me the last time Benin branch got the judge off the bench? Can you tell me? Yes, I'm saying the way this was. I am from Edo State. I'm home and if here. In what you get, when we go after you, we must get to have removed the former chairman of the branch, who was the high court judge. The former chairman of our branch, we dealt with him and we removed him. So this issue is not personal. It is easier to fight under the umbrella of the branch than to face this issue one-on-one. So the branch, I'm calling on the branch. The chairman is almost gone. The next chairman, don't be afraid to speak on behalf of your people. Don't be afraid. I'm never afraid to speak on behalf of the NBA. I'm never afraid. When I want to speak, I will have a little bit of fear. But when I'm confronting the system as a chairman or the head of that system, I'm never afraid because I am not talking on my behalf. So I'm calling on the branch to take that attitude, and you will find out that in this area there will be some sanity. If all of us are doing that, all the branches are doing that, there will be sanity. Therefore, those of us who are doing it, let me tell you something. You must not desire anything from the system. From the time you start desiring anything from the system, then you will compromise. I don't desire anything from the system. I keep telling the person. When I want to be a senior advocate, I don't care. I be a senior advocate, I don't do it. It's not my business. Do I belong to be a senior advocate? Yes. Will I do anything to be a senior advocate? No. Will I do anything to be a judge? No. If God says you want to be a senior advocate, you be a senior advocate. I met a member of the privilege committee who told me that when the application was submitted, but that was the height of the fight between Speeded and our former president. There was an opposition from the president on his qualification or on his being made a seat, and they asked him a simple question: is he qualified? Is not qualified? Take your NBA politics away from here. What I can tell you, the day God wants to honor you, nothing will stand. Don't be afraid. Now, when you fight those fights at their pushback, yes, for those who can remember, I did the jump quiz. The jump quiz. My daughter is in university, 200 level, but she has not been given her letter of admission or to speak. But I don't care. I believe in the judiciary. In as much as the judiciary is corrupt, I still believe in the judiciary. Remain in school. We will get justice, whether justice like it or not. I'm not afraid. So those are the kind of fights we should on our own handle from time to time. What is the reward? When I move, I go to the airport. I see people who come to me, who come to just thank me for what I do, pray for me for what I do. People I don't know. So there are rewards. When people pray for you, nothing can come and harm you. So ladies and my dear colleagues, the way forward is just do your bit in your own way and be satisfied. Can this system be reformed? I don't think so. The system will collapse also in its due time. But for now, do your bit. Thank you. I give me the opportunity to thank my panelists, the members of the branch for the opportunity. By the grace of God, next year we do it again. The session has come.
Well, that's it. Please, chairman of session, distinguished colleagues, today's discussion, you agree with me, has been very thought-provoking, as much as quite enlightening. And we are very, very deeply indebted to the chairman of session and of course our very distinguished speakers. We
We appreciate your presence, and you have given us our take home today for us to do a reflection on ourselves and how we can promote the goodness in the judiciary and, of course, the rule of law. Please, distinguished ladies and gentlemen, let's give the chairman and the panel a huge round of applause. Thank you so much. Before I call on the secretary of the branch to give us a vote of thanks, I would like to mention that members of the bar who are here seated will be having lunch right here. So our lunch will be shared, and we are advised to be armed with our meal ticket and also to be seated, because the meal will be shared to those who are actually seated on their meal ticket. And of course, for our distinguished guests, let us see present here the chairman and ESCO members, past chairman of the branch. We will be having our lunch upstairs right after this section. Right about now, please join me as I respectfully invite the secretary of the branch, Mr. Chris Otasumi. Let's put our hands together for him as he gives us a vote of thanks.
The chairman of the session, the acting with indulgence to once again stand on the existing protocol. I do not intend to take your time further, except that this vote of thanks is going to be very ceremonial in nature. On behalf of the Nigerian Bar Association, Benin branch, I want to thank sincerely the chairman of the session, our very senior brother, Akoko Martins, for the job well done. I thank our NSA, Kule Edu, for doing justice to the paper. I thank our own David Ogolo, a very rugged senior comrade in the struggle. I appreciate you for the raw truth that was told to the audience here, irrespective of how we all felt about it. I want to sincerely thank an erudite Professor D. Ragwe, the orator of University of Benin. Thank you so much, sir. We've drawn so much inspiration from right from our days in University of Benin. I'm most grateful. Our own very distinguished autonomous professor of law. Yes, autonomous professor of law. We thank you, sir. OGs everywhere, it's always a pleasure to have you here. Whenever we think of resource persons and we look inward, your name always pop up as number one. We'll thank our very legacy, Kembosia, thank the former Attorney General of the States, Mr. Wole Uzi. Thank you, sir. We appreciate your interest continuously in the activities of the MPA branch. We will thank our very distinguished learned seniors, elders of the bar, past chairmen, the distinguished colleagues who are still here, even though the days past spent. We appreciate you. We thank you most sincerely. We thank the amiable wife of our distinguished Secretary to State Governments. She's a distinguished colleague, as honorable as the husband is. The husband is a very senior colleague. He has been so supportive. Right, I remember I recall the first time the NPA approached him when he came to Benin. We didn't struggle to let him know that he was part of us. He immediately told us that because of his busy schedule, that he's very confident, he's assured us that the wife will always represent him, who happens to also be a distinguished colleague. But I will thank you. We are very proud to be associated with you and your husband. We are most grateful. On behalf of the NDA branch, we thank all presents. We are grateful and we encourage you all to also come out en masse tomorrow as we conclude the wind up the activities of the law week. We are most grateful. Thank you, Mr. Chairman. Thank you, the normal chairman. We are very grateful.
All right, please, we'll have the photo session right away. The chairman of section and the chairman of the branch. We have to the Vice Chairman. While the food is going around, please let's not forget that this evening we are all going to be at the Friendship Center. We are all expected to be at the Friendship Center for another round of relaxation, enjoyment along with the lawyers. Thank you so much. Please, for tomorrow, we are expected to be here by 8:30 a.m. And the topic for tomorrow is the role of courts in the enforcement of arbitration clauses in agreement and arbitration. Thank you very much.
Announcing. Keep announcing.
Please, we are encouraged for those who are going to have their families seated so you can serve honorably. God bless you. Thank you very much. See you at the Friendship Center and also see you tomorrow. God bless you.
So where is it? Let me give you.
Where's your mic?
This is your school.